The government became vindictive against some members of staff. Florence was singled out maliciously as having leaked information to people who didn't deserve that information. It was all false. Yours truly gave her pro bono legal services. And I scared away those who were tormenting her, and she continued working until today she's retiring. Honorable members, in honor of Florence Abono, I want to ask you to be upstanding. She will take a procession escorted by our members of staff who are here. When she gets to the door, you can go ahead and clap for her. Yes. Honorable members, order. Thank you, Rosa. Honorable members, may many of you serving in this house, privileged to serve in this house, even if you are not members of staff, pick a leaf from Florence Abono. It matters humility, matters dedication, matters respect, and matters commitment to this institution of parliament and to the country, and just serve and serve without expecting rewards. Thank you. Honorable members, before we go to the next order, allow me to recognize in the Speaker's Gallery, Kamacharia Girls High School from Mavioya, Muranga, and in the public gallery, Tembo Girls High School from Sotik, Bomet. On my behalf and on behalf of the House, we welcome the students, their teachers, and those accompanying them to the House of Parliament. Next order.
Order number 7, questions and statements.
Honorable members, we now go to statement. Umulkhair Harun.
Thank you, Speaker. Honorable Speaker, pursuant to the provisions of Standing Order 44-2C, I rise to request for a statement from the Chairperson of the Departmental Committee on Administration and Internal Security regarding abductions of a resident in Hulugo Sub-County, Garissa County. Honorable Speaker, on the afternoon of 6 February 2026, two men, Mr. Sambur Abdullahi Olo, a 75-year-old resident, and Mr. Mohammed Yaro, were allegedly abducted from their locality by individuals using two motor vehicles, Toyota Hilux make one black and one white. The white vehicle reportedly bore registration number KCR 8R, while the registration for the other vehicle is yet to be established. Mr. Sambur was forcibly taken from his compound, prompting his family to pursue the vehicles and successfully rescue him. However, Mr. Mohammed Yaro, who is believed to have been put in the second vehicle, remains missing to date. His continued disappearance has caused immense anguish to his family and the community and raises grave constitutional and human rights concerns. It is unclear whether the two victims were apprehended by security personnel or a criminal group. Honorable Speaker, it is against this background that I seek a statement from the Chairperson of the Departmental Committee on Administration and Internal Security on the following. the whereabouts and status of Mr. Mohamed Yaro, including an indication of whether he is in the custody of any state agency and the actions being taken to secure his immediate release, findings of investigations into the events of 6 February 2026, including the ownership of motor vehicle, registration number as indicated, whether the said vehicle is associated with any security agency and any disciplinary or criminal actions taken against those found culpable, and safeguards in place to prevent abductions, arbitrary arrests, enforced disappearances, and the impersonation of security personnel. Mr. Speaker, this adds on to the other statements I'd raised earlier with regards to Mohamed Yale and other 4 young men who are also missing from Garissa and are yet to be returned, and the ministry has not provided any sufficient response. Thank you.
Chairperson for which committee? Yes, yes, Chairperson, Internal Security.
Yeah, thank you, Madam Speaker. We'll attempt to respond in 2 weeks' time. And Honorable Speaker, in regards to what the member had alluded of several other unresponded statements, Honorable Speaker, majority of them had elapsed at the end of the 4th session. But as our procedures and standing orders, if the person has not been found, she can as well do the same statement again. Thank you, Honorable Speaker.
Thank you. The next statement requested by the Honorable Walter Owino.
Thank you, Madam Speaker. This is request for statement regarding delayed settlement of dues owed by Sony Sugar Company. Honorable Speaker, pursuant to the provisions of Standing Order 44.2c, I rise to request for a statement from the chairperson of the Departmental Committee on Agriculture and Livestock regarding the prolonged non-settlement of arrears owed to sugarcane farmers, sugar factory workers, and other service providers by Sony Sugar Company. Honorable Speaker, in May 2025, the government finalized the leasing of 5 state-owned sugar factories. By then, Sony Sugar Company had accumulated unpaid salaries, gratuities, pension contributions, leave allowances, and other lawful monetary entitlements owed to workers. Additionally, the company owed sugarcane farmers, cane transporters, and suppliers who had delivered goods and services. The Ministry of Agriculture and Livestock Development undertook to settle all outstanding accrued arrears as at the lease handover date by July 2025. Honorable Speaker, despite the undertaking, the farmers, suppliers, and employees who lost their jobs after the restructuring by the private investor are yet to be paid. They have persistently followed up with the relevant authorities, but neither have their dues been settled nor clear settlement plan and timeline for payment of their dues provided. This situation has continued to erode confidence in the sugar sector reforms and subjected livelihoods that relied on the sugarcane value chain to severe economic distress, including inability to meet basic needs, service loans, pay school fees, and access medical care. Honorable Speaker, it is against this background that I seek a statement from the chairperson of Departmental Committee on Agriculture and Livestock on the following. 1, reasons for the failure by the ministry to settle arrears owed to workers, farmers, and suppliers to Sony Sugar Company by July 2025 as earlier indicated. 2, the total amount owed to workers and farmers, indicating the number of persons affected following the restructuring of Sony Sugar Company by the private investor and amount due to each. And 3, the measures by the ministry specifying the budgetary provisions made to ensure immediate settlement of all pending arrears and their timeline for payment. Thank you, Madam Speaker.
Yes, what's your point of order?
Madam Speaker, I thank you very much for the opportunity and allow me to join my brother, Honorable Walter Owino of Awendo, This matter is not unique to Sony Sugar. It actually cuts across all the 4 government-owned sugar companies. Madam Speaker, last May 2025, on the 19th to be specific, there was gazettement of new leases to the sugar companies, Honorable Speaker. And it had been promised that before the new investors came into office, the government of Kenya was to pay all the pending dues to workers and to farmers alike, Honorable Speaker. Of course, on top of that, are onward sales of sugar that had not been settled, Honorable Speaker. There are people who paid for sugar to be delivered. That transaction occurred, and people lost money. And these are liabilities now accruing to these sugar companies, Madam Speaker. So even as the Agriculture Committee will be sitting down to look in depth into these issues around sugar and sugar companies, it is important to make sure that we collate all the outstanding dues to workers in all these sugar companies, together with all the farmers, Honorable Speaker. If we do not do this, there are many people, 70% in number, who actually offloaded from the former companies by the new investors, Madam Speaker. These people cannot take their children to school. They cannot attend to their sick in various hospitals. Some have actually died as a result of frustrations, Madam Speaker. So this is a matter that we need to expedite, get deep into the bottom of it, so that we can have this matter resolved once and for all, Madam Speaker. And I thank you for the opportunity.
Chairperson, Agriculture and Livestock.
Thank you, Honorable Speaker. Honorable Speaker, sugar issues are burning at the moment, and we have had a lot of issues surrounding the payments. So I believe in 2 weeks' time we can give the statement. We've just been having an engagement with the State Department, and about a third of the time has been spent on discussing sugar issues. So I'm sure the ministry is alert on the issues, and they'll give us a good report in 2 weeks.
Thank you. 2 weeks. Okay, next statement by the Honorable John Gakusha, member for Mukurueni.
Thank you, Honorable Speaker. Honorable Speaker.
You changed places. Okay.
Honorable Speaker, pursuant to the provisions of Standing Order 44 2C, I rise to request for a statement from the chairperson of the Departmental Committee on Education regarding the non-grading of the Kenya Sign Language in the 2025 Kenya Certificate of Secondary Education Examination, KCSE. Honorable Speaker, the Kenya Sign Language, KSL, was offered and administered as a subject to students without hearing impairment, who are more than 12,000 candidates in the 2025 Kenya Certificate of Secondary Education, KCSE, examinations. However, despite examining the non-deaf candidates, whom would refer as the students without hearing impairment in the subject, the Kenya National Examination Council, NEC, excluded KSL grades in computing their final grades. This academically disadvantaged the students in the computation of aggregate grades, causing them to miss the minimum university entry grade. Honorable Speaker, the consideration of Kenya Sign Language in the final grading of students without hearing impairment in the 2024 examinations created a legitimate expectation among candidates, parents, and educational institutions that a similar approach would be applied in the 2025 examination cycle. Notably, neither the Ministry of Education nor NEC issued any circular, policy guideline, or official communication to the effect that grading of the Kenya Sign Language would be restricted to learners with hearing impairment. Despite the absence of such communication, NEC proceeded to register candidates without hearing impairment for the subject, allowed them to sit the examination, marked the scripts, and thereafter declined to consider the results. Honorable Speaker, it is against this background that I seek a statement from the chairperson of the Departmental Committee on Education on the following. 1. The justification for exclusion of Kenya Sign Language from final grading for non-deaf candidates in the 2025 examinations, despite the subject having been graded in 2024. Number 2, reasons why the Ministry of Education and NEC failed to issue any circular or communication on a change in the status of Kenya Sign Language as an examinable elective subject for candidates without hearing impairment, yet proceeded to register, examine, and mark their scripts. And 3, immediate corrective measure that the ministry intends to take to remedy the apparent procedural lapse to protect the academic outcomes and ensure equal treatment of the approximately 12,000 candidates affected nationwide. I thank you, Honorable Speaker.
Thank you, Chairperson, Education Committee. As usual, it's not there. Chairperson, Majority Leader, you want to hold brief?
Yes, Honorable Speaker, I will relay that to the Chairperson Education, Honorable Meli. He was here, I don't know where he has stepped out to.
Okay.
At least the Chair Education is
But
seen
do you
in the House.
undertake on his behalf?
Maybe
2 weeks?
give us 2 weeks, Honorable Kagushia. 2 weeks. Where is Kagushia?
Kagusha has crossed the floor. Thank you. The Honorable Member for Embakasi West, Honorable Mark Mwenje.
Thank you. Apologies, Honorable Speaker, to retrieve my statement. Thank you. This is a request for a statement regarding alleged grabbing of a public utility land in Umoja and Embakasi West constituency. Honorable Speaker, pursuant to the provisions of Standing Order 44.2c, I wish to request for a statement from the chairperson of the Departmental Committee on Lands regarding the alleged grabbing of a public utility land in Umoja, Embakasi West constituency. Honorable Speaker, the parcel of land LR number Nairobi block 109-2380, situated along Moi Drive in Umoja area, Embakasi West constituency, was originally designated as a public utility intended for the benefit of residents. Despite the need for essential facilities, including provision of a bus terminus to serve public service vehicles operating along the area, the land has allegedly been illegally occupied by a private individual. This alleged encroachment has raised concern amongst residents who rely on the facility for essential social services. Such encroachment, if not forestalled, could undermine public confidence in land administration and deny communities access to essential services. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Lands on the following. 1, a report on the current ownership status of LR number Nairobi block 109-2380, situated along Moi Drive in Umoja area, Embakasi West constituency, including details of any allocation or change of user that may have been undertaken and the legality of such allocations or changes, the steps being taken to investigate the alleged land grabbing and restore the land to its intended public purpose. 3, the immediate measures being taken to ensure that the residents regain access to the land for its intended public benefit. And 4, the long-term measures in place to safeguard public utility lands from encroachment or misuse. I thank you, Honorable Speaker.
Thank you, Chairperson, Lands Committee. Majority Leader, it seems the Chairperson for the Lands Committee is not here. You can hold their brief and give an undertaking on their behalf.
Honorable Speaker, the Chair Lands Committee, I have not seen him today and the Vice Chair, but I will relay this to them and probably ask the Honorable Mwenje to give us another week or 2. This is in Nairobi. A week should be sufficient. 2 weeks. 2 weeks, okay.
Okay, thank you. The next is Member for Loima, Honorable Prontos Akuja. Give him the mic. Can you see where he is? Okay.
Thank you, Honorable Speaker. Honorable Speaker, I rise to request for a statement regarding lack of National Transport and Safety Authority services in Turkana County. Honorable Speaker, pursuant to provisions of Standing Order 44.2C, I wish to request for a statement from the chairperson of the Departmental Committee on Transport and Infrastructure regarding the unavailability of services by the National Transport Safety Authority in Turkana County. Honorable Speaker, the NTSA is established under the National Transport and Safety Authority Act, Cap 404, and its mandate is to regulate transport, safety, register license, monitor vehicles, conduct inspections and certification, regulate public service vehicles, and administer driver testing and licensing, among other critical functions. In furtherance of this mandate, the authority has established branches and county offices across the county to enhance provision of services. However, despite Turkana County being the largest county by landmass, covering an estimated 77,000 square kilometers, it does not have a functional NTSA branch. Due to this, Honorable Speaker, residents are forced to travel long distances, often to Eldoret town in Uasin Gishu County, to access essential services such as driving tests, insurance and collection of logbooks and number plates, motor vehicle inspections and other services. This imposes significant financial and logistical burden on residents, including transport costs and other related expenses. These circumstances undermine the constitutional principles set out under Article 232(1)(c) of the Constitution, which requires public services to be provided promptly, effectively, and equitable to all citizens. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Transport and Infrastructure on the following. 1, the immediate plans by the Ministry of Roads and Transport to provide NTSA services in Turkana County, including specific timelines. Number 2, the long-term measures by the Ministry to ensure equitable decentralization of NTSA services to underserved counties, such as Turkana County, across the country. And this will ensure that all of us reach Singapore at the same time with other Kenyans. Thank you, Madam Speaker.
Thank you. Chairperson, Transport and Infrastructure. Okay.
Honorable Speaker, on this one, I think Badi Twalib can speak, but probably you should direct the clerk to write to the Chair Transport Committee and the Vice Chair to inform them that the House resumed business on the 10th of February, and this is the second week, because they are never here. The Chair and the Vice Chair Transport Committee are never here. Since we opened, I have never seen them, set my eyes on them. Maybe you can direct the clerk to write to them, to inform them. Maybe it skipped their diaries. You know, they are very busy people. And inform them that the House resumed on Tuesday last week, 10th of February.
Thank you. Okay.
But there's a member maybe
that
who
has
can...
been noted and shall inform the committee.
Okay. Thank you, Madam Speaker. I want to assure the member for Loima that in the next 2 weeks' time, you will get the response. Thank you.
I think we have at least Honorable Twalib has committed on behalf of the committee. We shall hold you to it. The next, we have a statement by the Honorable Lomboko. Milema.
Thank you, Honorable Speaker. Is a request for a statement regarding the payment of monies to teachers by the Kenya National Examination Council. Honorable Speaker, pursuant to provision of Standing 44.2c, I wish to request for a statement from the chairperson of the Departmental Committee on Education regarding the delay in payment of monies to teachers and other examination personnel by the Kenya National Examination Council. Honorable Speaker,
In October 2025, the Kenya National Examination Council, NEC, engaged approximately 30,000 examiners for the Kenya Certificate of Secondary Education, KCSE, and 15,000 teachers as examiners for the Kenya Junior Secondary Education Assessment, KJSEA. The said teachers dedicated their time and rendered critical national service, often working under demanding conditions and away from their families. Regrettably, the Council is yet to disperse approximately 2.7 billion owed to the teachers as remuneration for their services. Further payments due to supervisors, invigilators, center managers, and marking centers also remain outstanding. These delays reflect a recurring pattern that adversely affects educators, disrupts their livelihood, and undermines morale within the education sector, while also raising concerns about the sustainability and integrity of the national examination process. It is imperative that the Kenya National Examination Council upholds fair labor practices and promptly fulfills its financial obligations to examination personnel, whose professional commitment should not be met with prolonged financial hardship. Honorable Speaker, it is against this background that I request for a statement from the chairperson of the Departmental Committee on Education on the following. Number one, the reasons for the delay in disbursement of funds to teachers who served as examiners for the Kenya Certificate of Secondary Education exams and the Kenya Junior Secondary Education assessments in October 2025. Two, the expected timeline for the full disbursement of the outstanding payments to all affected personnel. And three, measures being put in place to prevent recurrence of such a delay in future examination cycles, including timely budgeting and establishment of a clear payment timelines to ensure prompt remuneration of examination personnel. Honorable Speaker, you recall that even invigilators, supervisors, center managers, and all other staff involved in these examinations in October 2025 are yet to be paid. And this has caused a lot of pressure and unhappiness in the sector. Thank you, Honorable Speaker.
Thank you. I think that's also for the Committee on Education. Yes. Give Majority Leader the mic.
Honorable Speaker, as Honorable Mboko says, in a week, I'll relay that to the Chair Education.
Okay.
And good thing Mwalimu is a member of the same committee. Since when? You left? Oh, yes. He's no longer a member.
Because you would have patent bias.
But he has deep interest in that committee.
Yeah, because you have the patent bias, so you can't be a member of the committee. I think next is Majority Leader. You have your usual statement.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provisions.
There is a point of order, Honorable Majority Leader.
Honorable Speaker, thank you for the opportunity for this point of order. Last week on Tuesday, the 11th of February 2026, I requested for a statement from the chairperson of the Departmental Committee on Defense, Intelligence, and Foreign Relations regarding 2 Kenyans who were reportedly coerced into the military service of the Federal Republic of Russia. One Justice Ombati Mayenda is said to have been injured. One Justice Mayenda Ombati is said to have been injured while at war, fighting for Russia. He's in hospital. Mr. Clinton Nyapara Mogesa is said to have died at war, fighting for Russia. And the families are suffering. The families are worried how they can get the body of Nyapara back here and Mr. Ombati back here in Kenya. The Speaker ordered that the chairman brings the statement today. I'm wondering, Madam Speaker, I haven't seen the chairman around. I don't know when the statement is going to be laid in the House. I thank you Madam Speaker.
Thank you. I think, Honorable Member, there was a report on Russia yesterday by Majority Leader. I don't know, unless yours, it's, the factors are distinct from what the Majority Leader reported. Maybe Majority Leader explain? Okay, maybe you can explain.
Honorable Speaker, it looks like Honorable Nchoke has a specific one because I saw him raising his hand. But on the Russian matter, I did give the statement as was directed by the Speaker last week, yesterday afternoon. And it covers many of those instances, and I remember in that report, there are 39 Kenyans who are hospitalized in Russia, quite a number of others who are maimed. One was reported dead, and Honorable Nchoke, maybe you could have a look at that in the table office, or I can give you a copy in my office to have a look and see if it addresses the particular case you're asking for.
I think, Honorable Nchoke, would you like to clarify, just so that we know if yours is different from what was reported by the Majority Leader?
Yes.
Then Majority Leader can take note of it. But if it's similar, then I think you're free to go to the office of the Majority Leader to look at the report if it was comprehensive enough.
Thank you, Madam Speaker. I've gone through the report that was laid here yesterday by Honorable Ichungwa from the NIS and from the National Police Service. It's a good report, but it's generally a very generic general report. But my statement sought the two cases. A statement of two cases for Clinton Nyapara, who is reported dead in Russia, and Justus Ombati, who is said to be in hospital, also in Russia. Very, very specific, Madam Speaker. And neither of those two names are covered in the report that the Honorable Ichungwa laid before the House yesterday. I've gone through the reports.
What direction would you give him, Majority Leader?
Maybe we'll ask the Chair Security to check for the specific details, but I strongly believe, like the person he speaks about who is reported to be dead is among those who are reported. The 39 who are in hospital could be among those who are there. But also for us to understand that this is a war zone. There is nothing much that the embassy in Moscow will do to get access to those people in the war zone. And therefore, even the flow of information is not as quick as we would expect. It's not Kenyatta National Hospital, Honorable Speaker, or another hospital within our jurisdiction, but I will relay that to the Chair Security to see if he can fish out any specific information on those two particular cases.
But also, Majority Leader, since the DCI is seized of the matter, maybe you can report the names to DCI so that it can become part of their investigation, which is ongoing. Because they actually cited that there is ongoing investigations still. Is that satisfactory? Honorable Nchoke, one last shot.
In my view, Madam Speaker, I don't in any way to, I understand you, but you can appreciate the limitation of DCI or DCIO, whether it can go all the way to Russia to do the investigations. But probably should be the embassy, our embassy in Russia that can help us if the two cases happened and are in Russia. I thank you.
The two reports that came to Parliament yesterday was from NIS and DCI, and they do work with our embassies. Yes, they use the embassies, and they will normally have security attachés at the embassies. So they would still use, we don't have to be specific on the way they conduct their investigation. Once you tell them to conduct the investigations, they use all the channels that are available. I think we are done now, isn't it? Yes.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provision of Standing Order 44.2a, I rise to give the following statement on behalf of the House Business Committee, which met on Tuesday, 17 February 2026 to prioritize business for consideration during the week. Honorable Speaker, let me appreciate honorable members for settling down fast and enabling the House to embark on transaction of business of the House in earnest. Indeed, in just 1 week, The House has already concluded the second reading of 5 bills and is scheduled to vote on the second reading of the 6th bill, which we already did, Honorable Speaker, earlier this afternoon. Additionally, the House has so far passed 3 substantive motions, including the motion on the on the appointment of the Director General of the Financial Reporting Center and the petition on regulation of TikTok in Kenya. Honorable Speaker, this progress is a sign that the House is already on the right trajectory for achieving optimal performance this session. Honorable Speaker, with regards to business schedule for next week, the House is expected to consider the following bills at various stages, some of which are listed in today's order paper. Committee of the Whole House on the Judges' Retirement Benefits Bill of 2025. 2, a second reading of the following bills, should they not be concluded today. 1, the Miscellaneous Fees and Levies Amendment Bill 2025. 2, the National Infrastructure Fund Bill 2026. And 3, the Energy Amendment Bill, Senate Bill number 42 of 2023. Additionally, Honorable Speaker, debate will be undertaken on the following motions. 1 is a 7th report on the audited accounts of the National Government Constituency Development Fund Board for the financial years 2016, 2017 to 2021, 2022. 2 is the 8th report on the audited accounts of the National Government Affirmative Action Fund for the financial years 2016, 2017 to 2021, 2022. 3 is a report on the audited accounts for the Judiciary Mortgage Scheme Fund for the financial years 2011, 2012 to 2021, 2022. 4 is a 9th report on the audited accounts of the National Government Constituency Development Fund for constituencies in Nakuru County for the financial years 2013, 2014 to 2021, 2022. And 5, consideration of the report of the delegation to the 150th Assembly of the Interparliamentary Union. The House will also prioritize consideration of the following motions for which the relevant committees are expected to submit their respective reports next week. 1, consideration of a nominee for appointment as a permanent representative of UNEP, United Nations Environment Program. 2, consideration of a nominee for appointment as a chairperson of the Public Service Commission. 3, session of paper number 3 of 2025 on the partial divestiture in Safaricom PLC by the Government of Kenya. And 4, session of paper number 6 of 2024 on the National Aviation Policy. Further, Honorable Speaker, the House Business Committee noted that various bills that were referred to mediation committees are yet to be concluded. Instructively, Article 113 of the Constitution requires a mediation committee on a bill to undertake the mediation process within 30 days. I want to urge our members representing the National Assembly in the respective mediation committees to take note of the constitutional provisions and engage the Senate, our Senate counterparts with a view to prioritizing pending mediation processes on bills. Honorable Speaker, with respect to the appearance of Cabinet Secretaries to answer questions from members, I wish to restate that question time will be resumed at an appropriate time after concluding the budget process. However, as members may recall, yesterday the House adjourned its business to discuss a matter of urgent national importance regarding the drought situation in northern Kenya, following which I undertook to invite the relevant Cabinet Secretary to address the matter. In this exceptional regard, I wish to convey that in accordance with the provisions of Standing Order 42A5 and 6, the Cabinet Secretary for Public Service, Human Capital Development and Special Programs will appear before the House on the afternoon of Wednesday, 25th February 2026, to respond to question number 002 of 2026 by the member for Wajir West, the Honorable Yusuf Farah, MP, regarding the current drought situation in Turkana, Marsabit, Mandera, Wajir, Garissa, Isiolo, and Samburu counties. In conclusion, Honorable Speaker, the House Business Committee shall reconvene again on Tuesday, 24th February 2026, to schedule business for the rest of that week. And I wish to lay this statement on the table of the House. And thank you, Honorable Speaker. And Honorable Speaker, if you could indulge me, the reason why we go through this statement every week is to appraise members on the business that is likely to, subject to the meeting of next week, Tuesday, of the House Business Committee, what is likely to appear before the House next week. And I say this, Honorable Speaker, because a number of committee chairs are absent when their reports are on the floor. And we did indicate last week as we began, we will prioritize a number of committee reports, a number of private members' bills and motions, so that they do not lapse at the end of this session. So I really want to urge all our chairs, if you are not there to move or process your business, please make sure your vice chair is available. If your vice chair is not there, one of the other 13 members of your committee can do that work on your behalf, so that we do not derail any work of the House because we do not have a chair. And I think from next week, we have indulged one committee this week whose business, the Honorable Chepkonga was called in for a meeting yesterday, abruptly just before his business, and we indulged him, so his business has been rescheduled. But from next week, if we skip your business, that's it. We will not come back to it. To Honorable Speaker, I have alluded to the fact that we will be considering the National Infrastructure Fund Bill of 2026 and also the partial divestiture of in Safaricom by the government of Kenya, the session of paper number 3 of 2025. And I did mention earlier, Honorable Speaker, I got a clip this morning when the member for Suba North, Millis is Suba South, isn't it? So, Suba South, the Honorable Karoli Omondi was saying on TV that he forced them, I don't know who are them, to introduce this bill, the National Infrastructure Bill. You know, Honorable Speaker, I am the sponsor of this bill. And the Honorable Karoli Omondi has no capacity to force me to do anything. Zero capacity. 2, he just does not understand the processes, and he's a person I was alluding to when I said we must take time when you are new in this House to learn the processes. By the time a bill is introduced here, it has gone through many other processes. This bill was considered in cabinet last year at the end of November or early December. Cabinet, the last cabinet meeting, or the second last cabinet meeting last year in December, announced, or if you read the communique they gave, they say they are going to establish a national infrastructure fund and a sovereign wealth fund.
And the president raised it in his State of the Nation address.
Ahead of that,
yes,
the president had spoken to it. Then went to cabinet, processed the bills in cabinet. They were sent to this House last year. And we processed those bills, they were ready. I remember in December myself, while speaking to the media, NTV, because I am a respecter of House rules and procedures, and I never wanted to anticipate debate. Ibrahim Karanja of NTV asked me that particular question. Why are you not establishing a law? And I told him, Parliament is still sitting. And who tells you when Parliament resumes, there will be no law? Because I knew the bill was already in the House. That bill matured by the time we had we resumed. It was published and is already undergoing public participation. Therefore, for a first-time member to want to look intelligent or brave and say that I forced them to introduce a national infrastructure bill, you know, it's very embarrassing. And I said, I must take it up on, and I wish Honorable Karoli Omondi was here, because you shall not use this House to go and do cheap politics on national TV or on TikTok. If you are looking for bites to do on TikTok, please look for other things, but not, especially business that I am sponsoring.
Honorable Mboko,
because I take my work very seriously.
Is a point of order? Yes.
I have a lot of respect
a
for
point
the
of
leader, and
information
I
or
know
point of
he's
order?
executing his work. Honorable Speaker, I want to ask the leader that, you know, the young members of parliament must also look for some easy, cheap credit outside there. And publicity for bonga points. And when one of them picks something from you and pretends it's his own, I want to ask you and beg you that you just treat them with a little bit of kindness, because they must also survive. Thank you, Honorable Speaker.
You know, Honorable Speaker.
You have concurred with the majority leader.
You know, Honorable Speaker, I take Honorable Mboko's advice, but he speaks about a young member of parliament. This member is not young, and he doesn't look young at all. But he's a first-time member of parliament who should take time to learn the processes and procedures in the House. Because you can't say that you are forcing the House, or them, I don't know who are them, because the clip I got, he said them, that I forced them to introduce the National Infrastructure Bill. I only say that,
Honorable
Honorable
Chepkonga,
Mboko,
what is your
because
point of
I will
information?
allow Honorable Chepkonga to inform me, but just to respond to Honorable Mboko, I was saying I only raised it because it may look like it is Honorable Karoli Omondi that forced me to introduce this bill. If Karoli reads the Kenya Kwanza manifesto, on page 10 of that manifesto, it says we shall establish a national infrastructure fund. Karoli had not even read the Kenya Kwanza manifesto. So he cannot go to claim credit for what he has no idea of. He should just be patient, wait for the bill to come here. If he has anything substantive to say or input to give to improve the bill, improve. If he has nothing, please don't use this house, and that was the point I was raising, Honorable Speaker, when the substantive speaker was there. Don't use business in this house to go and do your cheap politics out there, please. And I said it yesterday, Honorable Speaker, let us be kind enough to ourselves, because it is the house we portray badly out there. When you go and say those things you are saying on TV because you want to look intelligent or sound intelligent. You may sound but not look, or you may not be intelligent by sounding intelligent. Honorable Speaker, let me allow Chepkonga to inform me as I finish.
Mr. Speaker, Madam Speaker, you know, I listened to Honorable Karoli Omondi. He's a good friend of mine. Unfortunately, as the majority leader has just said, he completely went off tangent. In fact, I just wanted to inform the majority leader that, in fact, one of the things that he claimed, that he financed the ODM to the tune of over 300 million shillings. Mr. Speaker, if you look at Honorable Karoli Omondi, does he look like 300 million shillings? Mr. Speaker, Madam Speaker, I have even invited him to come for a fundraising in my constituency, but he has refused a number of times. I was shocked to hear, and so I'm wondering why Honorable Milemba is sympathizing with a person who has a lot of money. He does not require. In fact, Madam Speaker, he said that he donated to ODM, and you know I was in ODM. He donated to ODM Chungwa House. You know, Madam Speaker, for you to donate Chungwa House, you require to be sympathized with. And in fact, Madam Speaker, I want to inform the majority leader that he said that he's no longer a member of ODM. He wants to form his party. So I don't know, he was speaking in what capacity, as against our good Senator Eddie Okech, who spoke a lot of sense, Madam Speaker. I thank you.
Okay, last point of order, Honorable Millie.
Thank you, Madam Speaker. But I think the honorable member is misleading the House. Honorable Karoli didn't talk about 300 million. He said he supported ODM to the tune of 700 million. So when you are saying, you need to be saying correct things, Madam Speaker. Honorable Karoli, as you say, is called Dangote because he's very well managed. Madam Speaker, you know us as Subas. We are Subas, we are a minority. So even when a minority takes on the majority leader, just be kind to him. As we are minorities, and as minority, we are proud of our few minorities. So I would request you next time, especially because Karoli, as you rightfully say, he may not be young, but he's a first timer. So please bring a substantive motion next time so that he also gets time to respond to you. I think that is a better rule of debate, because it would be nice for him to learn from you as you debate, as you raise points of orders against him and he responds, so that even when you raise 300, he can also tell us the source of 700. I also want to be also rich like Karoli.
Yes, the majority.
Honorable Speaker, you know, it is true the Honorable Karoli Omondi is a Suba, from Suba North, like Millie. Suba South, and Millie is from Suba North. And the indomitable Cabinet Secretary for National Treasury, Honorable John Buddy, is a penultimate Suba from Suba South. Honorable Speaker, you know, Millie is a minority whip. I saw in that clip also the member claiming that he is being removed from a committee. And Millie, who is his neighbor, is a whip. And I want to state here, because I am the chair of the selections committee, the minority whip has not proposed anybody's removal from any committee. So don't go seeking cheap publicity out there. But if, and the Honorable Karoli Omondi, I have engaged with him, he knows he's chairing a committee that he should not be chairing. And therefore, let me just say it here. He will leave the chairmanship of that committee, because that committee must be chaired by the majority side. And he knows it. I have engaged with him, and I advised him on what to do. Then he goes on national TV to say, oh, I am being removed, trying to portray now that probably is Honorable Millie or the minority leadership that is removing him. I want to state he will leave the seat of the chairmanship of the CIOC committee, because he was not to chair that committee. It is a majority side committee. And we are a house that respects political parties. We have a working arrangement under the broad-based government with ODM. That is why Professor Nyikal, Dr. Nyikal, is the chair of our health committee. That is why the Honorable Fatuma, who is a very diligent chair, you see how much business she had this afternoon and how efficiently she was able to give all those notices. And she will sit here throughout the afternoon sitting to see if any of her business will be arrived at. Now, a member who never sits here, only sits here for 2 minutes, then runs off to a TV station to say, oh, I am being removed from a committee. Oh, I have 700 million shillings to donate. I donated 1,000. You donate whatever you want to donate to your political party. But don't disparage the work of the House. That was my point, Honorable Speaker. And I have nothing against the Honorable Karoli Omondi. It is just my simple advice to the not so young members and the young members who are serving their first term. Take your time to learn the processes, because you cannot force anybody to introduce a bill here, even a private member's bill. Honorable Undo has been here. He has introduced very many bills. This member for 3 years has not introduced anything. Thank you, Honorable Speaker.
Thank you. And before we proceed, I'd like to recognize the Nyandarua National Polytechnic from Oljoro Orok constituency in Nyandarua County, who are seated in the public gallery. And on behalf of the substantive speaker, myself, and the entire National Assembly, you're welcome to Parliament, and I hope that you shall benefit from the deliberations. Thank you. Next order.
Order number 12, Committee of the Whole House.
Great honorable members, we are in the committee with the whole House, and specifically to deal with the Judges' Retirement Benefit Bill, National Assembly Bill number 27 of 2025. This one was sponsored by the leader of Majority Party. So, Leader, we shall be relying on you for the many amendments, and we ask you to take your seat so that we may proceed.
Clauses 3, 4, 5, and 6.
Honorable members, I propose the question that clauses 3, 4, 5, and 6 be part of the bill. And these ones don't have an amendment. I now put the question, Honorable Leader, order. Thank you. I now put the question that clauses 3, 4, 5, and 6 be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 7.
I propose the question that clause 7 be part of the bill. Chairperson.
Thank you very much, Honorable Chair. Chairperson, I propose that clause 7 be amended as shown on the order paper. This is purely to remove some words that found their way onto the bill when they are not necessary. Like the word we are removing is a public, which is misplaced, should not be there. Before the commencement of this act was appointed a judge, not a public. Thank you. I beg to move.
Honorable members, I propose the question that clause 7 be amended as proposed by the mover. I now put the question that clause 7 be amended as proposed by the mover. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it. I now put the question that clause 7 as amended be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clauses 8 and 9.
Honorable members, I propose the question that clauses 8 and 9 be part of the bill. And now that there are no amendments on these ones, I proceed to put the question that clauses 8 and 9 be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 10.
I propose the question that clause 10 be part of the bill. Mover.
Thank you, Honorable Chairperson. Honorable Chairperson, I beg to move that clause 10 be amended as shown on the order paper. And this is purely a cleanup, such that the words we are removing, retirement age, are misplaced. They are not supposed to be there. This appears to be a typing error. I beg to move.
I propose the question that clause 10 be amended as proposed by the mover. And now put the question that clause 10 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it. I now put the question that clause 10 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clauses 11, 12, 13, 14, 15, and 16.
I propose the question that clauses 11, 12, 13, 14, 15, and 16 be part of the bill. Honorable members, I proceed to put the question that clauses 11, 12, 13, 14, 15, and 16 be part of the bill. Will as many as that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 17.
I propose the question that clause 17 be part of the bill. Chairperson.
Thank you, Honorable Chairperson. I beg that clause 17 be amended as shown on the order paper, and that is clause 17, subclause 2. And the word that is misspelled there is been. It's spelled as being. So we want to delete being and replace it with been. Thank you.
I propose the question that clause 17 be amended as proposed by the mover. Did I hear Honorable Millie say something? You want to say something on this one?
Sorry, Chair, I support because really that's not even a substantive amendment, but we support in general.
Very well. Honorable members, I put the question that clause 17 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 17 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clauses 18, 19, 20, 21, and 22.
I propose the question that clauses 18, 19, 20, 21, and 22 be part of the bill. Honorable members, there are no amendments on these ones. and I therefore proceed to put the question that clauses 18, 19, 20, 21, and 22 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 23.
I propose the question that clause 23 be part of the bill. Mover. Yes, I know there are two amendments there, but let's go first with the chair. There's one by yourself and then by the leader.
I thought they're the same. Leader, look at you. I think it's the same proposal.
Okay, but,
I beg
but
to
then
move.
order, Honorable Chair. Let's give priority to the leader. So leader goes first.
Honorable Chair, is actually the same amendment that we both have. And may I move that clause 23 be amended as provided for on the order paper. Honorable Chair, this is to provide for an enhanced and pension benefits for the current 4, or what would be the 5 Supreme Court judges who are not either the Chief Justice or the Deputy Chief Justice. As you are aware, the Chief Justice and the Deputy Chief Justice have their retirement benefits under the Deputy President and Designated State Officers Act. But the judges, the other 5 judges, and now with the demise of Justice Ibrahim, there are 4, they have other duties, administrative duties that they do on behalf of the court. And this involves a lot of other work that is administrative, that they do on behalf of their colleagues in the judiciary. They take care of their judicial infrastructure and buildings. They look after the welfare of judges and staff of the judiciary. They are the ones who are involved in the development of rules and regulations of the court, training, and both the bar and those on the bench, and also managing the bar and bench relationships between Mili, Murugara, and other lawyers and members of the judiciary who are serving. And therefore, they have a lot of additional responsibilities, and also they are serving in the apex court. And therefore, to put the Supreme Court judges on the same pedestal with other judges would look a bit unfair and not very appreciative of the other administrative work they do. Therefore, we just seek to enhance not their pension, they will have their pension, but other non-pension benefits. And that would probably constitute, remember these Supreme Court judges are also the ones who deal with most of the very heavy, even political issues. They are the ones who look at presidential petitions. And therefore, post-retirement, I may have run for president and thought probably they made a decision that was not fair to me and target any one of them. And therefore, you need to assure them that they have non-pension benefits such as additional security, maybe a car and some fuel allowance. And therefore, that's all we seek to do here, to give them that additional non-pension benefits, but they will enjoy the same pension as the others. But we give them additional non-pension benefits, Honorable Speaker. And I beg to move.
No, allow me to propose the question first. Honorable members, I now propose the question that clause 23 be amended as proposed by the leader. Yes, Chair? Oh, Chiponga.
Mr. Chair, I rise to agree with the leader of majority that indeed, by the time you reach the apex court, in which you deal with only serious constitutional issues, Mr. Chair, you deserve to be rewarded better than the other judges. You know, for us, some of us that have appeared severally at the Supreme Court during the presidential petitions, and I've appeared, I think, twice. Mr. Chair, that is high-octane politics. In fact, they have to sleep in an hotel. They don't go to their houses. It is a very serious matter. And so, you must reward such people, Mr. Chair. You know, they are no longer lesser mortals like some of us who deal with issues that are earthly here. You know, they have been at least upgraded a little bit. You know, I have been praying that one day, serious people like Honorable Millie Odhiambo become judges of the Supreme Court. The only problem is that your brother went ahead of you. So I don't know what we will have to do. One of these days we'll have to ask him, our own brother, the senior judge, of course. No, he's not a super, I know he's a Luo, but you know you must balance some of these things at the Supreme Court. So, Mr. Chair, I support this particular amendment.
Very well.
Very important.
Honorable Wino.
Okello.
Okello.
I thank you very much.
Nyando.
Yes, I thank you very much. I'm in line with the proposal as advanced by the majority leader, Honorable Speaker, for one to actually serve at the Supreme Court. Look at what happens in the United States of America, for example. The rigorous process through which they are taken through evaluation and re-evaluation, including that of their personal conduct and character, Honorable Speaker, is so deep that, you know, they have to really be properly remunerated, Honorable Speaker. I remember in 2013 when we presented the best petition in the world, Honorable Speaker, the Supreme Court rejected our 800-paged evidence, Honorable Speaker, 800 pages. I don't know, to collect an evidence of 800 pages, Honorable Speaker, within that short span of time is a sacrifice, Honorable Speaker. Then they rejected. So it is true that some people may be holding all those into their hearts with an intention for rebuttal or retribution, Honorable Speaker. And therefore it is important. Only what we need to do is to cap the number of security that they should be accorded. Maybe 2 or 3, or maybe depending on the risks that they are subjected to, Honorable Speaker. But if we leave it open-ended and with the constricted security that we have in the country where we don't have enough, it may be abused or susceptible to abuse, Honorable Speaker. So yes, if it will be on application, but again, I think there will be a review of the dangers that they are exposed to before such a decision is taken. Honorable Speaker, again, in 2017, you know what transpired.
No, you must not debate. You just need to make a comment.
I just wanted to say that the former president was very angry at the decision of the Supreme Court that if he had powers to attack, Honorable Speaker, nothing could have stopped him from doing so. And therefore, I agree with this. They need beefed up security upon retirement.
Great. And your concerns on security of... Okay, on those concerns about security, I think the leader has proposed a schedule in which that will be dealt with. But let's hear from Honorable Millie.
Thank you, Chair. Chair, of course, I wish to support that amendment. And Chair, Honorable Jared Okello is giving the example of the President Uhuru when he was very mad at the decision. Chair, I am a classmate of Honorable Justice Lenaola, who is the chairman of our class group, which is called the MV90. And I left the group as soon as they made that decision. Of course, being a politician, I was that angry. I left the group. But of course, after a while, of course, you relax, you heal. But imagine if there are people who don't heal. They'll just blow them off. But I also want to just indicate that it's not just in terms of security alone. The nature of Kenyan government is hierarchical. So really, we don't even need an excuse. If you are Supreme Court, it's the apex judge. They are the apex judge, court rather, and they are the most senior judges. So really, it really just makes sense that they should get better benefits. Mr. Speaker, Chairman, the mistake we normally do is the Kenyan Parliament. And I was hearing Honorable Ichungwa and several of us who are senior. Many times we refer to new members, people serving their first term. But every time I come now, I'm doing my 4th term, same salary as new entrants. And so Parliament, we are the ones who set laws and set systems for people and discriminate against ourselves. We must always, we must also think about ourselves. Yeah, even if it means that we make those laws and they apply after 10 more years, so that it's not benefit to us, but we must follow the system that applies to everybody in the country. The same salary that will be paid to say, my dear sister here, Honorable Njeri, is the same one that will be paid to me, who was not only in the house, but outside. I've told you I'm a classmate of Honorable Lenaola, who is in the Supreme Court. But I'm paid the same salary as a 20-year-old who has been elected in his constituency.
Very well, very
so
well.
let us, but finally, just one little thing. I know that I've been challenged here that I have my brother in the Supreme Court, of course, ethnically. I've really thought, I don't see any Suba who is in Supreme Court or has ever been. So Subas, we still want that Supreme Court. And if indeed we get to a point where we negotiate for deputy presidency, I'm hearing everybody making noise. Suba must be. Suba.
Very well. I think this one has been overwhelmingly supported, but I just want to hear the leader.
Chair, thank you. And I want to agree with Millie that first, also as a matter of hierarchy, the Supreme Court judges warrant something extra. But also the second part, Honorable Speaker, that I forgot on this amendment is to take care of a Supreme Court judge who leaves office before attaining the age of 65 years. Again, we are providing for that any Supreme Court judge who leaves office before attaining the age of 65 years, for whatever reason, there may be health reasons or you want to retire early, you will still be entitled to access your non-pension benefits under that subsection 1 and the schedule. And maybe what Jared was asking, the schedule, if you look at the schedule on page 086, you will see there is actually one driver, a fuel allowance, 2 armed security guards provided on request. If you feel you don't need to request, 1 housekeeper and a cook. Those are the non-pension benefits.
We shall come there, but leader, the house.
So my brother from my school, the Honorable Isaac Lenaola, is well taken care of here.
Thank you.
Because he went to the school.
Leader, members who are also very anticipatory that will speak about the ranking members and their salaries vis-a-vis the newly coming in members. All the same, honorable members, allow me to put the question that clause 23 be amended as proposed by the mover. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it. I now put the question that clause 23 as amended be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clauses 24, 25, 26, 27, and 28.
I propose the question that clauses 24, 25, 26, 27, and 28 be part of the bill. There are no amendments on these ones. I proceed to put the question that clauses 24, 25, 26, 27, and 28 be part of the bill. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 29.
I propose the question that clause 29 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. I propose that clause 29(4) be amended as shown on the order paper. And what is happening in that clause is that when we named the subsection, which is subclause 3B, C, D, instead of having E, we got an I. So we purely want to correct this. The typo is removed and the subsection becomes neat. Thank you. I beg to move.
I propose the question that clause 29 be amended as proposed by the chair. Honorable members, there's nothing here really. Let me proceed. I now put the question that clause 29 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 29 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. Chair, you must keep alert as we move with you. And we must hear your voice on this. Even if we hear no other voice, your voice must be heard. Okay, we proceed.
Clause 30.
I propose the question that clause 30 be part of the bill. Chair.
Thank you very much, Honorable Speaker. Honorable Chairperson. Again, we propose that clause 30 be amended as shown on the order paper. And what is happening here purely is just to correct a typo in that the appointments under the trustees, for the trustees, is under section 29 and not section 30. So we replace section 30 therein with section 29. I beg to move.
I propose the question that clause 30 be amended as proposed by the chair. I now put the question that clause 30 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it. I now put the question that clause 30 as amended be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clauses 31, 32, 33, 34, 35, and 36.
I propose the question that clauses 31, 32, 33, 34, 35, and 36 be part of the bill. Honorable members, there are no amendments on these ones, and therefore I proceed to put the question that clauses 31, 32, 33, 34, 35, and 36 be part of the bill. Will as many as without opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 37.
I propose the question that clause 37 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. I propose that clause 37 be amended as shown on the order paper. And what we are doing here is purely to ensure that we comply with the law, the Constitution, by introducing that when the Cabinet Secretary determines what remuneration is to be paid to the trustees, it is on the advice of the Salaries and Remuneration Commission. On the advice. Those are the words we are introducing to make this compliant with the law. I beg to move.
I propose the question that clause 37 be amended as proposed by the chair. I now put the question that clause 37 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 37 as amended be part of the bill. Will as many as without opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clauses 38, 39, 40, 41, 42, and 43.
I propose the question that clauses 38, 39, 40, 41, 42, and 43 be part of the bill. Honorable members, there are no amendments on these ones. Allow me to proceed and put the question that clauses 38, 39, 40, 41, 42, and 43 be part of the bill. Will as many as without opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 44.
I propose the question that clause 44 be part of the bill. There's an amendment on this one, Chair.
Yes, thank you very much, Honorable Chairperson. I beg that clause 44, in particular subsection 2, subclause 2C, be amended as shown on the order paper. Here we are simply adding the word after so that it makes sense in that interest that the additional voluntary contributions under the FAD, together with the accrued interest thereon, after leaving employment for any reason. That's the word after we are introducing. Thank you. I beg to move.
I propose the question that clause 44 be amended as proposed by the chair. I now put the question that clause 44 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it. I now put the question that clause 44 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54.
I propose the question that clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54 be part of the bill. Honorable members, there are no amendments on these ones. I proceed to put the question that clauses 45, 46, 47, 48, 49, 50, 51, 52, 53, and 54 be part of the bill. Will as many as of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it.
Clause 55.
I propose the question that clause 55 be part of the bill. There's an amendment. Chair.
Yes, thank you very much, Chairperson. I beg to move that clause 55 be amended as shown on the order paper. And the rationale is this exactly what we are doing. First, we are renumbering so that we have a second subclause. For us to do that, we must introduce subclause 1. Then we have subclause 2, which now as the subclauses 2 and 3, which as the following provisions. A judge of the Supreme Court to whom this part applies shall, during their retirement, be entitled to the additional benefits set out in the schedule. And number 3, subclause 3, a judge of the Supreme Court who leaves office before attaining the age of 65 years shall be entitled to access the non-pension benefits under subsection 1 and the paragraphs A and B of the schedule. The rationale is to provide for enhanced non-pension benefits for a judge of the Supreme Court appointed to office after the commencement of the legislation. The Supreme Court has 7 judges. We know for sure the Chief Justice and the Deputy Chief Justice draw their pension from a different law, and therefore it is important that we make a provision for the rest of the judges. Then the amendment also allows a Supreme Court judge who leaves office before attaining the age of 65, for whatever reason, to access their non-pension benefits, including what has actually been set out in the schedule, to include transport allowance, medical cover, diplomatic passport, and access to government lodges, etc. I beg to move.
Honorable members, I now propose the question that clause 55 be amended as proposed by the chair. And if this one is taken, then the one of the leader will actually fall because they are actually the same. Let's hear from Ridikiri, Honorable Ridikiri.
Thank you, Mr. Chairman. I think today is going to be a history of the law process in this country because we are now taking a full responsibility of ensuring one of the arm of the government is taken care of. Harmonization is very critical because we have seen the Supreme Court judges drawing from one kitty and the other judges are not. So this bill is causing harmonization, and that's what we really want. It has been a practice everywhere in the world that there must be sequential harmonization of all the benefits that accrues to the members of the judiciary world over. So I support this and say I think this is the best thing that the judiciary will enjoy this year.
Very well. Honorable members, I now put the question that clause 55 be amended as proposed. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it. I now put the question that clause 55 as amended be part of the bill. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it.
Clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65.
I propose the question that clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65 be part of the bill. Honorable members, there are no amendments on this one, and I therefore proceed to put the question that clauses 56, 57, 58, 59, 60, 61, 62, 63, 64, and 65 be part of the bill. Will as many as without opinion say aye? Will as many as are contrary opinion say nay? The ayes have it.
Clause 66.
I propose the question that clause 66 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. Allow me to move that clause 66 be amended as shown on the order paper. And what we are doing here is to renumber the sub-clauses such that we have a clause 1 in 66 and introduce a new subsection 2, which reads as follows. A judge of the Supreme Court to whom this part applies shall during their retirement be entitled to additional benefits as set out in the order paper. And this is purely to provide for enhanced non-pension benefits for the 2 judges of the Supreme Court that were appointed under the new constitution and have already retired. The 2 judges are not covered by the Retirement Benefits Deputy President and Designated State Officers Act, Chapter 197B of the laws of Kenya. This is the second schedule. We shall be talking to it, the additional non-money benefits.
I propose the question that clause 66 be amended as proposed by the chair. And of course, if this one is taken, the one of the leader will actually fall. Honorable members, I proceed to put the question that clause 66 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 66 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 67.
I propose the question that clause 67 be part of the bill. Chair.
Thank you very much, Honorable Speaker. Honorable Speaker, I do propose that clause 67 be amended as shown on the order paper. And what we are doing is to delete clause 67 and introduce a new clause 67 as follows. Clause 67(1), the Cabinet Secretary shall be responsible for the payment of pensions and gratuities to judges under this act. This is purely just to align it with the law that pensions are under the Cabinet Secretary, Treasury. Now, we're introducing clause 2 that the Chief Registrar of the Judiciary shall administer the non-pension benefits under sections 23, 55, and 66 of this act, and provide for them in the estimates of the judiciary prepared pursuant to Article 173(3) of the Constitution. What we are doing is we must separate the pension, the monies coming from Treasury, and the non-monies that are being administered by the Chief Registrar of the Judiciary, the motor vehicles, the security, the cooks, and everybody else. Then number 3, we've combined a responsibility for them that the Cabinet Secretary and the Chief Registrar of the Judiciary shall establish a liaison office to facilitate the timely payment of pensions, gratuities, and the provision of non-pension benefits under this act, purely to facilitate for the judges who are retiring. Where do they go for their pensions? These are old men and women past 70 years. We don't want to keep them out there moving from one office to the other. They need to know where to go. They get their pensions and other benefits one stop. This is the liaison office. I beg to move.
I propose the question that clause 67 be amended as proposed by the chair. Yes, Honorable Millie.
Thank you. I just wanted to correct the chair when he called 70-year-old old. Those are advanced age. They are not old.
Okay, the chair is corrected. Ridikiri, what do you want to say about this?
You know, our judges, and I need to stand collected, these people are very isolated by virtue of their work. Sure. So they rarely have so many friends like Mary Odhiambo because she is all over and she is known all over. Judges leave the office, go to their home and back. Now, these people need to be taken care of. Otherwise, some of them might lapse. Immediately they retire. So these benefits are very important and they need to be properly managed. They should not go home and start asking, where do I start? They need to continue the life they have been enjoying. So I support this.
Okay, Honorable Gishimo.
Thank you, Chair. I support this amendment.
Judges, and especially the Supreme Court judges, having served at the highest level in the judicial system, require dignity. They require an office which can really serve them, having sacrificed their mind, their effort, everything in their life to serve justice in this country. So I support this is a very good amendment, and it will make their life easy after retirement.
Honorable members, I now put the question that clause 67 be amended as proposed by the chair. Will as many as other opinions say aye? Will as many as contrary opinions say nay? The ayes have it. I now put the question that clause 67 as amended be part of the bill. Will as many as other opinions say aye? Will as many as contrary opinions say nay? The ayes have it.
Clauses 68, 69, and 70.
I propose the question that clauses 68, 69, and 70 be part of the bill. No amendments. I proceed to put the question that clauses 68, 69, and 70 be part of the bill. Will as many as other opinions say aye? Will as many as contrary opinions say nay? The ayes have it.
Clause 71.
I propose the question that clause 71 be part of the bill. Chair.
Thank you very much, Honorable Chairperson. I beg to move that clause 71 of the bill be amended as shown on the order paper. What we are doing is we delete subclause 1 and substitute therefore the following new clause. That the Cabinet Secretary shall, within 12 months of the commencement of this Act, make regulations generally giving effect to the Act and for prescribing anything required or necessary to be prescribed by or under this Act. That is subclause 1. Subclause 2, we propose we insert the following new subsection immediately after subsection 2. These are clauses now. 2A, in making the regulations under this Act, the Cabinet Secretary shall obtain the views of relevant stakeholders, including the Judicial Service Commission and the Chief Registrar of the Judiciary. The rationale is that within a given period of time, and this must be maximum 12 months, we have regulations in place because we do not want a lot of bureaucracy when these judges, retired judges, are going for their pension. There may be forms to be filled, there may be other processes and procedures to be done. All these are contained in regulations. This is why we are saying that within 12 months, these must be attended to. If there are any set forms and precedents, this must be done within a period of 12 months. Then when making those regulations, the CS cannot sit alone and decide for the retired judges what is good for them. He must take views from the relevant stakeholders who include the Judicial Service Commission that pays them and the Chief Registrar of the Judiciary who administers especially the non-pension benefits. I beg to move.
Honorable members, I propose the question that clause 71 be amended as proposed by the chair. And Honorable Chipukonga, you had a similar amendment, and therefore, if this one is taken, yours will fall, but could we hear from you?
Yes. Thank you very much, Honorable Chair. Chair, I totally agree that once the chair's proposed amendment is taken, mine will fall by the way. And I support this, Mr. Chair. The reason, Honorable Chair, the reason why I proposed similar amendment, Honorable Chair, is because we want to provide something called certainty and clarity and remove something called doubt and equivocation on matters to do with the law, and particularly when it comes to benefit of judges. So we want to provide certainty in the sense that the Cabinet Secretary should be able to bring the regulations within 12 months of this law coming into operation. That will ensure that those judges who will be retiring have clarity on what they are expected to get, how much they are supposed to get, when, and in which place. I thank you, Honorable Speaker.
Honorable Mutuse.
Thank you, Chair. I stand in support of the amendment proposed to clause 71. Chair, if you look at the original section 71, it is already prescriptive. It was already saying what the regulations would say, which is not very good in legal drafting. And therefore, the amendment to shorten it so that the stakeholders, especially the Judicial Service Commission and the Chief Registrar, in liaison with the Cabinet Secretary, will come up with regulations that are not already prescribed in the parent act, and therefore support the amendment by my chair. It is very timely, it is effective, it is going to make the operationalization of the law easier.
Honorable Gidinji.
Thank you, Chair. While I support this amendment, I don't know whether I would persuade the Chair whether we can do away with Amendment B, because it goes without saying that for you to make regulations, you must do public participation. And this public participation must involve all the requisite stakeholders. So I believe, in my view, the Amendment B, which is seeking that the other stakeholders to be consulted for when the regulations are being made, is already covered under the Constitution, which provides that for any law to be made, whether an act of parliament or regulations, public participation, which must include all the stakeholders, must be involved. I believe this to me is somehow superfluous.
We've heard you, and I'm going straight to the chair to give that explanation, but also tell us, allow chair, also maybe tell us, why is the proposal that the regulations must come in 12 months? Why not a lesser time? Proceed, Chair. We shall hear.
Thank you very much. We don't need a lesser time means it's within 12 months, so we are covered.
Okay.
Good enough. What we are doing is we don't want the act to come into force. Another 2 years down the line, they don't know what to do. So it's also 12 months are sufficient for us to do exactly what Honorable Gishimo is saying, public participation and water view. Honorable Gishimo, for subsection 2A, this inclusion is not superfluous. I think it's very important because we have to consult all relevant stakeholders, but to be particular, because this affects judges whose remuneration is by Judicial Service Commission, and the Chief Registrar of the Judiciary, who is going to administer their non-pension benefits. I think we make it almost mandatory that they have to be included in the consultations that are to take place. This does not affect anything in any manner that is negative.
Very well. Gichimo was feeling like you were over-legislating, but let the matter will rest there. Okay, Gikaria, what do you have to say?
Honorable Speaker, I think the chair has actually, let me just say, it is important to have this regulation, Honorable Speaker.
Okay.
And one of the issues is because we have some Energy Act that up to date, since 2019, regulations have not come before the floor of the House. And we are actually finding it very difficult to operationalize some of the sections of the Act without the regulation. So I totally agree, but I also agree with you, Chair. 12 months is also quite a while. So how I wish.
He was able to answer that one, that within 12 months. So that's the higher limit. It can be in a lesser period. Honorable members, I now proceed to put the question that clause 71 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that clause 71 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 72.
I propose the question that clause 72 be part of the bill. Oh, honorable members, there are no amendments on these ones. I proceed to put the question that clause 72 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
New schedule.
We are on the new schedule. Chair, please move the new schedule.
Yes. Thank you very, very, very much, Honorable Chairperson. I beg to move that the schedule to the bill be read a second time. The justification is we start by finding this under proposed sections 23.2, 55.2, and 66.2. Additional benefits for a retired judge of the Supreme Court. I think we've elaborated the hierarchy of the judges in the country, and we find it proper that we do make a provision for additional benefits for the Supreme Court judges. The additional benefits include the following. You will get 1 car, you will get fuel allowance, he or she will get 2 armed security guards provided on request, which means the judge will choose whether they want security or not, will get 1 housekeeper and 1 cook. And justification is that we have to outline the enhanced non-pension benefits for all judges of the Supreme Court who are not covered by the Retirement Benefits, Deputy President and Designated State Officers Act, Cap 197B. The benefits are slightly higher than those of judges in other superior courts and below those of the Chief Justice and the Deputy Chief Justice. This is where we are placing judges of the Supreme Court, so that they are between the Chief Justice and the Deputy Chief Justice and the judges of the superior courts, the High Court and the Court of Appeal. I beg to move and request Honorable Rindikiri to actually second.
Does it really require seconding? No, Rindikiri will speak to it later. Honorable members, I now propose the question that the new schedule be now read a second time. Honorable Rindikiri, I give you the first chance to make your comments on this.
Thank you, Chairman. I have 2 comments. One, on the there is a requirement that we consider, in my view, a provision for a driver, because the bodyguard is there, and also the car, the capacity of the vehicle, that the judges will be entitled to retirement. I think that is not stipulated. I would like to ask the Mr. Chairman to consider those 2 as to be part of the package in the named schedule.
Very well, Honorable Chepkonga.
Thank you very much, Chair. I in fact rise to support the proposed schedule by the Chair. The reason being, Chair, is that, you know, what has been provided as the retirement benefit is in fact very frugal as far as I'm concerned. The reason being, you know, in the United States of America, the Supreme Court judges don't retire. They in fact sit in the Supreme Court until they die. So if they die at the age of 86, 87, so you can imagine, Chair, how much money they draw all that time. If you look at ours, they retired merely at 70. Still very strong, still very useful. They've done a great work for this nation. It is good just to reward 6, 7 people only, Mr. Chairman. I support.
So we hear Gichimu.
Thank you, Chair. These are additional benefits for a retired judge of the Supreme Court. The other benefits that touch on all the retired judges are already covered under the bill, including the car, which Honorable Rindikiri was seeking. So that is already covered, but probably on the matter of the fuel allowance, much as I support, I think that ought also to be determined. I think the regulations in consultation with the Salaries and Remuneration Commission, I think we'll come up with that bit of the allowance. And Honorable Chair, these are just bare minimum, and Kenyans should note that the heavy lifting that the Supreme Court judges usually do in matters of very national importance. So I think they deserve, and we have, this House will be remembered as having done the best for the judges in this country on matters retirement. Thank you.
Jemachia.
Thank you so much, Mr. Chair. Also, I want to reiterate and add my, on the schedule, that apart from all this, I don't know whether it is possible for the chair of the committee to add another advantage we can have, because when Honorable Chepkonga said,
Chair Murungaru, you're being addressed. Okay.
When Honorable Chepkonga said judges in the US, for instance, are not going on, they don't go for retirement, or they are not retiring, or they don't retire, it means they protect the institution, the memory of the institution. I don't know whether the chairman, you can add one as on the schedule also as a beneficiary, that judges who are able to serve, even in their retirement, can be called back one time to time for institutional memory and to give counsel. Because it is important when these people sit, we cannot just wish them away. That could be added to one of the, so that they can be always coming back to give us the best ruling and judgment.
Okay.
Thank you, Mr. Speaker.
No, Chair, I'll call you later. Let's hear Onchoke first, then we come to you, Chair.
Thank you, Mr. Chairman, and I support these amendments and this schedule for the additional benefits of the Supreme Court judges who are retired. Now, for all these benefits, the driver, the fuel, the armed security guards, one housekeeper, and one cook, I think it would be important maybe in the regulations to give them the amount, so that some judge doesn't decide, I want a cook at 2,000 shillings, at 200, so that it's uniform for all of them. That would be very important, in my view, Mr. Chairman.
Oh, so the two still go to the chair. So let's hear from the chair.
Right. Thank you very much, Chairperson. Regulations will be coming. So most of the concerns we have will be addressed through regulations, which are actually the flesh of any act of parliament. It's regulations that tell us exactly what parliament meant when they made that provision. In those regulations, including rendering some expertise when required, whether opinionated, provided doesn't go against the Constitution, which provides that their retirement age is 70 years and it cannot be renewed. However, if there's a way this is going to be looked at, there is absolutely nothing wrong as to what they will be getting in terms of fuel allowance. Again, the regulations will make a provision, and even if the regulations will make provision for salaries of the helps, the cooks, the drivers, and what have you, they will be free to do all that. It's for this parliament to approve or disapprove. Thank you, Honorable Chairperson.
Honorable members, I now put the question that the new schedule be now read a second time. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. I now propose the question that the new schedule be part of the bill. I proceed to put the question that the new schedule be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 2.
I propose the question that clause 2 be part of the bill. No amendments. I now put the question that clause 2 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Title.
I propose that the title be the title of the bill. I now put the question that the title be the title of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 1.
Honorable members, I propose that clause 1 be part of the bill. But there's an amendment by the chair.
Yes. Thank you very much, Honorable Chairperson. I rise on my feet now to move an amendment that clause 1 of the bill be amended by inserting the words, as soon as you name, and shall come into force upon publication in the Gazette, immediately after the expression Judges Retirement Benefits Act. That is how the act is called, and we have made a provision as to when it shall come into effect, when it shall come into force, which is also a requirement of legislation, that we know exactly when this act is going to come into force. It is as soon as it is assented to and it's actually gazetted, it now becomes printed by the government printer, it comes into effect. Thank you.
Honorable members, I propose the question that clause 1 be amended as proposed by the mover. Honorable Mutuse.
I stand in support. Support because this is very important. You know, sometimes you can delay the benefits to the judges by not operationalizing the law. And therefore, this because it now provides a safe mechanism for its own getting effective, so that the judges are certain that it will be implemented, and therefore this is extremely important.
Honorable members, I put the question that clause 1 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. And I'll put the question that clause 1 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Honorable members, we are finished with this particular one. We ask the mover to move reporting. Honorable Murungara, on behalf of the leader.
Thank you very much, Honorable Chairperson. On behalf of the leader of majority, I beg to move that the committee do report to the House its consideration of the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and its approval thereof with amendments. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Honorable members, Mr. Speaker.
Thank you, Chairperson. Reporting.
Very well, Honorable Speaker. I beg to report that the Committee of the Whole House has considered the Judges' Retirement Benefits Bill, National Assembly Bill number 27 of 2025, and approved the same with amendments.
Thank you very much, Honorable Speaker. Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request Honorable Jematia to second the motion for agreement with the report of the Committee of the Whole House.
Thank you, Mr. Speaker. I want to support the whole report of the House, of the committee, and then to second. And to second the report of the committee. Thank you, Mr. Speaker.
Thank you, honorable members. Thank you so much for your patience on this matter. I therefore now propose the question, which is that the House do agree with the committee in the said report. I would be minded to take any few interventions if there are any. If there are not any interventions, then I would, for obvious reasons, for obvious reasons, I would pend the putting of the question until we are properly prepared to do so. I will therefore call for the next order.
Order number 13, motion, consideration of the privileges and immunities, the Global Center for Adaptation Order 2025.
Who is the mover of this? This is the Honorable Chepkonga. I would imagine you still the chairperson of the Legislation Committee. Honorable Gishimu.
And
No, but is it true that he's still the chair?
Honorable Speaker, he is the chair.
But now you are the delegatee this afternoon.
Yes, I have leave to move.
Correct, yeah. So because what's the order of paper is that this is moved by the chairperson, and now it's on record that this chairperson is the Honorable Gishimu for this evening. Go ahead.
Honorable Chair, Honorable Speaker, I beg to move that this House adopts the report of the Committee of the Delegated Legislation on its consideration of the privileges and immunities, the Global Center for Adaptation Order 2025, legal notice number 82 of 2025, in accordance with the provisions of the Statutory Instruments Act, Cap 2A, and Standing Order 210. Honorable Speaker, the privileges and immunities, the Global Center for Adaptation Order 2025, is a statutory instrument made by the Cabinet Secretary for Foreign Affairs and Diaspora Affairs, for Foreign and Diaspora Affairs pursuant to Section 11 of the Privileges and Immunities Act, Cap 179. The legal notice was published in the Kenya Gazette on the 2nd May 2025. Thereafter submitted to the Clerk of the National Assembly on the 30th May 2025 and tabled before the House on the 4th June 2025, whereupon it is stood referred to the Committee on Delegated Legislation for scrutiny in accordance with Section 12(1) of the Statutory Instruments Act, Cap 2A. The committee considered the order in line with the Constitution, the Privileges and Immunities Act, Cap 179, the Interpretation and General Provisions Act, Cap 2, and the Statutory Instruments Act, Cap 2A. Honorable Speaker, the object and purpose of the privileges and immunities, the Global Center for Adaptation Order 2025, is to confer privileges and immunities upon the Global Center for Adaptation, GCA, an international organization with which the government of Kenya has entered into a cooperation agreement to support climate adaptation initiative. And the order seeks to grant the organization legal capacity as a body, cooperate and confer privileges and immunities specified under Part 1 of the 4th Schedule of the Act, which includes A, the immunity for suit and legal process, inviolability of premises and official archives, and exemptions from certain taxes and duties. The order further confers privileges and immunities upon director, officials, and staff of the organization under Part 3 of the 4th Schedule of the Act, including immunity in respect of the acts performed in course of the official duties and certain physical exemptions. Honorable Speaker, in its scrutiny of the order, the committee made the following observations. that Section 17 of the Privileges and Immunities Act requires that any order made under the Act must first be submitted to Parliament in draft form and approved by resolution before publication. This requirement gives effect to Article 94, Article 6 of the Constitution, which provides that delegated legislation must be exercised strictly within the authority and standards set out by Parliament. And in this case, that authority and standard has already been set out under the Privileges and Immunities Act. Honorable Speaker, the Ministry of Foreign Affairs and Foreign and Diaspora Affairs did not prepare or submit a draft order to Parliament prior to consideration as required by the law, that is Section 17 of the Privileges and Immunities Act. The order was therefore published without the mandatory prior requirement that Parliament ought to approve it. And therefore, Honorable Speaker, pursuant to Section 16 of the Statutory Instruments Act, the committee invited the Ministry of Foreign Affairs just to give them a hearing and also hear their views on the matter. And also the National Treasury for consultation on this. And actually the National Treasury confirmed that they were not aware whether the order had been submitted to Parliament in draft form as required. And therefore, having examined the Act, the Privileges and Immunities, the Global Center for Adaptation Act 2025, and against the Constitution and the relevant statutes, the committee found that the failure to submit the draft order to Parliament before publication infringed on the Constitution, that is Article 94, sub-Article 6 of the Constitution, which provides the effect of, or which provides that the delegated legislature must be exercised strictly within the authority and standards set out by the Parliament. Of course, in this case, through the Act of Parliament that it is embedded. And therefore, it also contravened Section 11 and 17 of the Privileges and Immunities Act, Cap 179, and violated Section 13A of the Statutory Instruments Act, Cap 2A, which requires that the statutory instruments conform to the enabling law. Honorable Speaker, accordingly, the committee had no option other than to recommend that this House declares the Privileges and Immunities, the Global Center for Adaptation under 2025 Legal Notice number 82 of 2025, a nullity for failure to comply with the Constitution and the applicable statutory requirements governing the delegated legislation. Honorable Speaker, however, much as this order may have been well-intentioned, it had to follow the requisite procedure provided under the Act under which it is made. So let me be very clear while moving this and seeking the House to agree with the Committee on Delegated Legislation in annulling this order, that the committee has no or did not dwell into the nitty-gritties of this order, having considered that the requisite procedure was not followed, then it was not necessary now to move into the other issues of whether public participation was conducted, whether all the other requisite conditions for delegated or regulations were made. So we found that the law was not followed, as I've already explained, and I beg to move, Honorable Speaker, and I now call upon Honorable Member from Bonchari, Honorable Onchoke, to second.
Grace in the House. Go ahead.
Thank you, Speaker. Today I'm sitting here. I've been promoted. I rise, Honorable Speaker, to second the motion that this House considers to nullify the order of the privileges and immunities for the Global Center for Adaptation, Order number 2025. On the face of it, about 3 or 4 laws were breached. They were never followed. So the committee didn't even have to go into the merits of this order and the purpose for this order. And the committee...
The Honorable Francis, that was Francis Kimani Kuria. You can't do that, and you know it.
And the committee, Honorable Speaker, the committee has noted that a number of these statutory instrument-making bodies have developed a habit of not bringing or following the law, not bringing the orders, the instruments to the House for consideration and approval. I therefore stand here to second this motion. I thank you.
Honorable Member, moving and seconding of that motion, I therefore propose the question, which is that this House adopt the report of the Committee on Delegated Legislation on consideration of the privileges and immunities, the Global Center for Adaptation Order, published as legal notice number 82 of 2025, and laid on the table of the House on Thursday, 4th December 2025, and declares that the privileges and immunities, the Global Center for Adaptation Order, legal notice number 82 of 2025, a nullity for failing to comply with Section 17 of the Privileges and Immunities Act, Cap 179, that requires the regulating authority, regulation making authority, to submit the draft order for approval by Parliament before publication of the order, and infringing Article 94(6) of the Constitution, relating to the principles and Section 13A of the Statutory Instruments Act, Cap 2A. The member for Molo, you want to contribute to this?
So, Honorable Speaker, I really want to applaud this nullification of this particular instrument, Honorable Speaker. And I think this is also a call for this Honorable House to be very careful about the laws that we enact. Because looking at some of the provisions that were contained in this particular act, Honorable Speaker, one of them was providing immunity from suit and legal processes for acts, omissions in official duties for these particular diplomats. They were being given exemptions from direct taxes or salaries emoluments. They were being given immunity from national service. They were given immigration and registration exemptions. They were being given exchange control privileges and repatriation facilities. They were being allowed, Honorable Speaker, free importation of anything, duty-free importation of furniture, personal effects, household goods on first arrival. Honorable Speaker, all these privileges, in as much as we accept, Kenya has become a hub of diplomatic missions, global, Honorable Speaker. And as we welcome even the decision by the UN to really set up a substantial office here in Nairobi, that does not mean that we need to advantage foreigners over Kenyan citizens, Honorable Speaker. And of late, you've seen some of these privileges that are given to these foreigners, Honorable Speaker. They end up abusing them. You know, Honorable Speaker, just the other day you saw the Russian guy coming to this country and doing all manner of things, including breaching our data protection laws. We know the allegations, the Honorable John Kagiri keeps talking about, Jane Kagiri talks about the intricacies being done to the people of Nanyuki. by the British army people who are training there, Honorable Speaker. And therefore, it's very important in as much as we become very welcoming, and we really welcome all these foreigners to come and invest in our country, to come and live here, to come and set up their offices
What
here.
is this Russian thing?
But, so, Honorable Speaker, there is a Russian who ameshikanisha inchi a few weeks ago. Some Russian guy, he came, he was wearing these sunglasses that has cameras. He was picking up women all over the place and doing all manner of unimaginable things with them and recording them, and later releasing them. And some of them are very embarrassing, Honorable Speaker, and has really degraded, even though some of the actions by those women may not be upheld as good, Honorable Speaker, but recording them, some of them are mothers, some of them, it has broken quite a number of marriages, Honorable Speaker, because some of them were admitting they are married, but they were really willing to do anything to go with that white man, Honorable Speaker. And perhaps we have a discussion with some of my friends, and this is some of the what do you call it? When growing up, all the soap operas that are fed to our children and to our girls, now people imagine that the only romantic men are white people, or the people that are not black. And many women also believe that if you get acquainted with someone who is white, or then utatoka block, you will get out of poverty. And therefore, they are willing to really go out and do anything possible, Honorable Speaker, as a way of trying to safeguard their fortunes, Honorable Speaker. So that is the story of the Russian guy. So it's very important, Honorable Speaker, that as we saw again last year, some Chinese employer, Honorable Speaker, slapping and beating up his employees. And I think we need to be, in as much as we need to be welcoming, this particular foreigners cannot operate outside the laws of our land. Whether it is our employment laws, whether it was the data protection laws, whether it is all those things that are criminal, those that are not, and we must safeguard our interests. Selfish, Honorable Speaker. If any of us goes and commits some of the crimes that these foreigners commit in this country, and we commit those crimes in their countries, Honorable Speaker, you will rot in jail in their countries. And it's a high time that as a country, we also take note of this. And those foreigners that break the lands of our land, they should be repatriated. We should ask them to be repatriated back to this country to face the full force of law, and they should be imprisoned here in committee, not taken back to their countries for imprisonment. Because like when Kenyans commit crimes in those other countries, some of them are thrown to jail. We have seen petitions coming from this house for members where they are saying some of their constituents have been jailed in India, others in other countries for years, for very many years for some very petty crimes. So we really need to be, not to allow again these foreigners to come from their countries to disrespect us, to disrespect our women, to disrespect our laws, to disrespect the laws of our land, and we should take as much as stern action to those foreigners as they will take on us if we committed those crimes in the respective countries. So for that, I really support the mover of the motion, the Honorable Gishimo, for this nullification. And again, we must be selfish as a country. And as much as we're opening our doors to foreigners to come in our country, it does not mean they come and demean us. It does not mean they come and take us as their slaves. They must come and follow the laws of our land. The same way, when you go to their land, we strictly adhere to their laws. And the same way they are strict on us if you break the laws of their land when they visit their land, the same way we should be strict on them when they come and break the laws of our land. I beg to support, Honorable Speaker.
Member for Jomvu, you want to speak on this? Member for Jomvu, this is your chance to contribute.
Okay. Asante. Mheshimiwa Spika, mimi pia nataka kuunga mkono na kukubaliana na yale maneno ambayo Mheshimiwa Kuria Kimani ameweza kuyasema. Kwa sababu Mheshimiwa Spika, tukiangalia ni kweli katika hii hali ambayo tuna watafadhalisha hawa watu ambao wanakuja hapa kama mabalozi na watu wengine katika nchi yetu, baadaye wanatumia nafasi hiyo kufanya vitu ambao sio sawa. Mfano, tuweza kuona watu wageni ama kwa kizungu tukisema foreigners, ambao kama huyu ambaye ametajwa hapa kutoka Russia, amekuja hapa, amefikia wasichana wetu, amewatongoza, amewafanyia makosa, alafu amevunja nyumba zao na kila kitu. Mheshimiwa Spika, ni lazima sisi utu wetu tuweke mwanzo. Na mambo kama haya Mheshimiwa Spika, tukiangalia unaona kama mabalozi pia ambao wanakuja hapa na wanakaa hapa wanapata msamaha huu pengine wa kuweza kuagiza mali ama vitu vingine. Unaona mtu anakuja mkora fulani ana import makontena ama magari, anasema ni personal effect za balozi fulani na halipi ushuru ambao ni wa nchi yetu. Mheshimiwa Spika, si jambo la sawasawa katika huyu Mrashia ambaye alituchezelea watoto wetu sana. Nataka kuambia Mheshimiwa Spika, ni kwa kuwa sawa kabisa asihukumiwe kimambo ya kuwekwa jela. Ye matatizo yake ni zile chengelele zake ambalo amezifunga kwenye suruale. Ni vizuri kwa kizungu zinaitwa ziwe castrated, yani afinywe na hayo maneno ili asirudie maneno kama hayo. Mheshimiwa Spika, leo huyu mtu mimi nashangaa Mheshimiwa Spika, amfikia mpaka mwalimu wangu mmoja nasikia sijui wa Mikindani kama wapi auliza mimi niko single kwa sababu ya ule Mrashia. Je, leo mheshimiwa ingekuwa amefika katika sehemu ambazo ameweza kueneza ugonjwa na mali pengine sisi tungekuwa kwa hasara. Kwa hiyo Mheshimiwa Spika, nayaangalia mambo haya kwa mambo mema, lakini tuyaangalie kwa tahadhari. Asante kwa kunipa nafasi hii, nashukuru sana na twalaani maneno ya huyo Mrashia. Asante.
You are all now confusing the House. There definitely is a difference between the Global Center for Adaptation and the Russian. Please go ahead and tell us the difference.
Mr. Speaker, you know sometimes in a very hard topic like this one, you take leave to discuss other issues of national importance. Mr. Speaker, I rise to support this, the Committee on Delegated Legislation's report, which is very important. And Mr. Speaker, this committee did not go into the merits of that particular order. As you have just heard the Chair of Finance, the Honorable Kuria, he has vividly stated that there are issues with regard to this order. We should have gone to the Ministry of Finance because it includes tax exemptions. Now, on question of tax exemptions, it cannot be done by the Minister of Foreign Affairs. This is a matter which can only be undertaken by the Ministry of Finance in accordance with the Constitution. Mr. Speaker, as you know, there's a plethora of laws, of decisions by the courts, which have held that procedure is as important as the substantive law itself. In this case, Mr. Speaker, the procedure that was adopted in seeking to grant immunities and privileges to this particular organization was complete in total breach. The law requires that that order must be brought in draft form to this House for approval before it is gazetted. Now, what happened, Mr. Speaker? This order was gazetted and it came into force irregularly, completely out of procedure. As you know, Mr. Speaker, anything that does not adhere to establish legal methods, rules, and regulations is of no effect. It is null and void. The reason why we have procedure, Mr. Speaker, it ensures that it prevents arbitrariness on those that are given power to make regulations. It ensures that we avoid chaos in lawmaking, Mr. Speaker, so that if procedure is not followed, everybody will just be coming up with anything that does not follow the law. And as you know, Mr. Speaker, Article 94 of the Constitution is very clear. It states that there is no person within the boundaries of this country that can make anything that has a force of law without the authority of this House, without the authority of Parliament. So, Mr. Speaker, anybody who attempts to grab the power that has been granted exclusively by the people of Kenya to this House, it will be frowned upon. And so, Mr. Speaker, the intention of having procedures is not to stifle the making of laws, but it is to ensure that there is fairness, there is justice in the manner we enact laws. As you know, Mr. Speaker, the courts will take a dim view on any person who fails to comply with procedure as laid down by this House. This will ensure that these procedures, Mr. Speaker, regulate rights and privileges that are enjoyed by Kenyans and any person who comes into this nation. Just to mention just a few things that we noted, Mr. Speaker, which we did not put in our report if we had to deal on the merits of this matter. Mr. Speaker, this is an organization that was established in the Netherlands. And it came into this country having been registered in that other country, Mr. Speaker. And we wanted to know why it deregistered itself in that particular country. Mr. Speaker, there was no public participation that was undertaken, as required by Article 118 of the Constitution and Article 10 of the Constitution. So, Mr. Speaker, clearly, this was in total breach of the Constitution. So this order in itself is unconstitutional, Mr. Speaker. So I support that this order be declared null and void by this House. And therefore I support. I thank you, Mr. Speaker.
Member for Funyula. Thank you, Honorable Speaker. Let me also join the Committee of Delegated Legislation, or rather let me support the report of Committee on Delegated Legislation on recommending to nullify in its entirety the privileges and immunities the Global Center for Adaptation Order published as legal notice number 82 of 2025, based on the facts that have been presented to us by my good friend, the MP for Gishugu, who happens to be a member of the committee. And Chair, Honorable Speaker, for record purposes, I was a member of the committee in the last term, but this term I have not been a member of the committee. Honorable Speaker, the Global Center for Adaptation is an international organization that was established as part of the Paris Agreement on climate change resilience and climate change management. Its headquarters is in the Netherlands, and of course the fundamental questions that we need to start asking: to what extent, whether there is a diplomatic mission or not, that's a question we need to answer, and probably in the fullness of time, we need to have to ascertain that particular notice. But Honorable Speaker, the mere fact that the State Department for Foreign Affairs proceeded to publish and enforce the order without the approval of Parliament is the highest level of impunity, is the highest level of breach of the Constitution. Honorable Speaker, truth be told then, whoever appended his signature or her signature in getting the order published breached the Constitution, acted unconstitutionally, and therefore, Honorable Speaker, is liable for a sanction probably under the various articles of the Constitution of Kenya, because you cannot purport to be a public servant who have sworn to uphold the Constitution, and you are the very first person to disregard the provisions of the Constitution and proceed to publish the order and get it enforced. I would want to challenge the committee. I can see the chair and the vice chair are in animated discussion. You need to ask whoever signed and published the order to really come and account for that unconstitutional edict. To be honest, we cannot allow that level of impunity to prevail and go unpunished. That is unacceptable in the modern day. Honorable Speaker, we tend to favor these diplomatic missions even beyond what we do to our own people, who slug out day and night to get things moving. And I want to commend the committee for having stood up. I'm sure there must have been a lot of pressure from the executive or other corners to get it passed. But at least for the very first time, your side had the courage to say, no, and to uphold the constitutional provisions. Honorable Speaker, we even ask Kenyans, when we go out of this country, for either to work or not, I've been to very many missions, talking to diplomats there, and they're very clear in their views. They say they have to comply with the laws of the country. The diplomatic immunities that are accorded is only for the mainstream diplomatic missions that are truly and purely accredited by that country. And whichever way, there are some things that are a no-goes on. Things about taxation, things about having immunity against criminal action is something that is beyond, this cannot be entertained in those countries. Why us here in Kenya, we allow that kind of a thing to happen and then let these foreigners go scot-free is baffling. It's just a continuous act of dereliction of duty for those people charged with those offenses. Honorable Speaker, there are very many times foreigners commit offenses, they're scripted away at night, so that by the time they have to answer for those offenses, you are told they're no longer in the country. As I stand here today, Honorable Speaker, the man who was being beaten in Eldoret by the Chinese comes from my constituency. I asked a question here, they have never received an answer. The gentleman was badly injured. Nobody has ever bothered to attend to them. In this disguised view that we want foreigners to invest in our own country. As Baba Mo used to say, nobody will come from anywhere to develop this country. We have to do it ourselves. And if we have to do it ourselves, we must be extremely hard on these foreign investors who come to with nothing most important to invest and get us done, get moving. As I conclude, Honorable Speaker, I want to urge the committee to remain courageous in view of the intimidation you normally have to receive. Remain courageous, and God will forever remember that you existed and probably saved this country from one of these funny things that is going to happen. Thank you, Honorable Speaker.
The member for Marsabit.
Thank you, Honorable Speaker, for giving me this opportunity to add my voice to this very important debate. And from the onset, I support this motion. And Honorable Speaker, I support it because of the experience that we are having in this country of late, and even in the past, because many of our citizens have suffered in the hands of foreigners. And I support this because the committee has made the right observation. And I like what they have said. Number 4, having examined the Privileges and Immunities Global Center for Adaptation, Order 2025, Legal Notice number 82 of 2025, in accordance with the Constitution, the Interpretation and General Provision Act Cap 2, the Statutory Instrument Act Cap 22A, and the Privileges and Immunity Act Cap 179. The committee recommends that the House declares Privileges and Immunities Global Center for Adaptation, Order 2025, Legal Notice number 82 of 2025, nullity for failure to adhere to Section 17 of the Privileges and Immunities Act. This, Honorable Speaker, is a serious gap that the committee members have observed. And I want to congratulate the members of this committee for standing in the gap and salvaging the situation. Honorable Speaker, if we cannot nullify this today, many Kenyans will suffer in the hands of foreigners who come in the pretense of investing in this country, starting companies that can employ our young people, and at the end of the day, many Kenyans suffer in their hands. The example that many honorable members have referred to is something that has moved the entire nation and the entire world. And just remembering the number of our young people who have been maybe infected by that particular Russian man is a story that will affect us for the rest of our lives. And many families, and I know many young people, many women today may be depressed of this. Honorable Speaker, we know very well that many investors have come and have mistreated members or citizens of this country. Some have even taken some very important documents from them, hidden their identity cards, their passports, mistreated them, used them as their workers, social workers or workers, and at the end of the day, without even paying them. And Honorable Speaker, nullifying this will save this country and also will give us our pride that we need. And with those few remarks, Honorable Speaker, I support. Thank you.
Thank you. Member for Gases.
Thank you so much, Mr. Speaker, for giving me this opportunity to also rise in support of the report of the Delegated Legislation Committee on the Privileges and Immunities, the Global Center for Adaptation, Order number 2025. And from the onset, Mr. Speaker, I rise to support the recommendation of the committee in rejection, in annulling in totality this particular order that was developed and published by the executive in absence of what the law has guided, that all the laws-making procedures is vested in this House, and the instruments of power as guided on the same. Mr. Speaker, this one is just a troubleshooting, and it could be inviting this House to extend its role in ensuring that we carry out an audit to establish all the instruments that are being used to run these organizations, to run the ministries. Because if this thing was done in silence, in contravention with the law, and was already deemed to be giving out powers to a foreign person, in this case, the Global Center for Adaptation, powers to up to including contravening the Tax Procedures Act, where all powers on exemption of taxation, as per the Tax Procedures Act, is now in the office of the Cabinet Secretary for National Treasury, of course in consultation with the relevant ministries when a matter arises. But all the powers are in the hands of the Cabinet Secretary for National Treasury. But already looking at this instrument, it was already subverting that power and giving out an advantage, a privilege to a foreign entity. And most of this issue is coming up because of the current occurrence in our nation, where we've seen friends who have been invited to the nation, friends who have come in goodwill. Some of them have come to facilitate the foreign direct investments. Some of them have come to give services in support of what government is doing in addressing the social needs of the people. But they end up abusing these particular privileges to carry on their interest, up to including exploiting our children in terms of the information that is not warranted for our young people, exploiting our women, exploiting our population in terms of labor. Some of them have come employing our people, using them beyond the limits without proper compensation, and even to an extent of coercing, an extent of subjecting them through stress, subjecting them through behaviors that our employment laws are totally against, just by virtue of the cover they've been giving. So with this one, I want to say that this House has done the right thing. I want to thank the Committee on Delegated Legislation, I see the Vice Chair is here, that they are doing the right thing, so that it's able to alert this House, so that we be keen. And remember, this House is established to protect the interest of Kenyans against all odds. And for this purpose, it is high time that the ministries, led by this ministry, should do the right thing, involve this House, because it's only this House guided by Article 118 that they can undertake proper public participation and public sensitization, stakeholder engagement, so that we're able to balance and don't cede out the privileges for our people at the expense of foreigners. So I want to support this particular motion and to say this serves as an example. We need to go further beyond here so that we safeguard the interests of Kenyans. Thank you so much, Mr. Speaker.
Thank you. Mr. Baringo, what happened to your card? Go ahead.
Thank you, Mr. Speaker, and sorry for not having my card ready for this time. Mr. Speaker, I also want to join my colleagues in supporting the work of the committee, and specifically Honorable Gishimu for moving this, because, Mr. Speaker, I keenly read this report, and I'm shocked that someone in the echelons of power or executive would even think for once that he can just break the law with all the disregard of even bringing this draft to Parliament. Mr. Speaker, I was so keen in the schedule of the Act, which was rejected by the committee, and this exemption of certain taxes and duties, and inviolability of premise and official archives, and even the immunity from suit and legal process. Mr. Speaker, this is a very dangerous organization. You can imagine someone seeking not to be subjected to any law of this country or of the land of Kenya, just because you probably want to do something that is unimaginable. And many times, Mr. Speaker, I think for once Africans should be happy being Africans. We don't have to hate, we don't have to look forward to be associating so much ourselves to these whites and imagining that they can do a lot of better things than us. And if you read history, you realize the industrialization and civilization of the world actually started in Africa. So I think I want to thank the committee for once because of refusing to be coerced and standing and protecting Kenyans by refusing this order to go through. Mr. Speaker, in previous times, I come from Baringo, and there was this runaway acceptance of global climate solution, sort of, where someone, I think it was from Canada or Brazil or wherever, decided that during Moi's time to come and help people of Baringo from mitigating desertification. And they brought this wild plant called madenge, which was accepted probably those days. But the adverse problems is being felt by the people who are not there and who did not make the decisions. So when someone makes a decision today, it doesn't affect them probably now. But when you're out of office, it is going to affect people who are very innocent. And it is very important for us as a member of parliament to continue protecting the people of Kenya and allowing things that can actually progress through the law. And also, I want to also thank the committee because the section of the privilege and immunities must pass through parliament. As long as this draft or this order did not pass parliament, it should not be allowed. And I hope the executive are not going to sneak this as a part of the privileges they have also, because they are feeling that their offices are important. Mr. Speaker, other issues, just like the way members have been complaining about the Russia and this Russia guy or this Russia man, I can't imagine the impact that he left. The terror that went through people's houses, the emotions that created through these young women or these exposed women, the problems that they are facing now in the society, the judgmentals and all those kind of things. Just because we allowed someone to run around, take photos, and up to this point, we have never seen a proper actionable, reasons or someone to take up and give us reasons why this guy, how did he even land in Kenya and what was he doing? And so that we are able to protect ourselves. Mr. Speaker, if you look at the way Africans generally behave, we are so welcoming and we always attract such kind of characters. And this is one of the reasons I want to thank the committee for studying firm and with finality nullifying this order to proceed. Thank you, Mr. Speaker, and I support the committee.
For Mungi Central, want to contribute to this?
Thank you, Mr. Speaker, for giving me this opportunity to contribute to this bill. Mr. Speaker, I rise to support the report by the Delegated Legislation Committee on their report on the privileges and immunities regulations for foreigners and foreign missions. Mr. Speaker, I would like to support the annulment of these regulations because they are against the Constitution of Kenya 2010, which states that no one is above the law in Kenya. Anybody can sue and anybody can be sued in Kenya except the President of Kenya when he's in power. Further, Mr. Speaker, the fact that the regulations were allowing exemption of taxes, this is contrary to the law, and anybody in Kenya earning a salary in Kenya must pay taxes in Kenya so that we can run our country effectively. And this, Mr. Speaker, will have opened a Pandora's box for others to join in and misuse their power and exploit other Kenyans on some of these exemptions. Mr. Speaker, this House should set a good example for those in power and for those in the executive, that you cannot wake up one morning and prepare your regulations to suit yourself and your friends and your cronies, so that in the future, they should know that there is a House of Parliament which makes laws and approves regulations. Mr. Speaker, to make such kind of regulations without consultation to Parliament, without public participation, is indeed usurping your powers to circumvent the law. And therefore, Mr. Speaker, this was illegal and should be treated as such. And therefore, let this annulment by the Delegated Legislation Committee set an example to those in the executive to abide by the rule of law in Kenya. Thank you, Mr. Speaker.
Thank you. There being no other interest on this, I would like to call upon the move of the Honorable Gichim to reply.
Thank you, Honorable Speaker, and I want also to take this opportunity as I reply to thank all the members of Parliament who have contributed and supported this motion. Actually, there is no single member who has opposed it. And just to indicate and to clarify to Honorable Oundo that the mandate of the Committee on Delegated Legislation is limited and, or actually is provided under Standing Order number 210, 3 and 4. And the best that this committee can do is, after scrutinizing the statutory instruments, is to recommend approval where compliance to the law and the requisite procedures has been met or have been met, and to recommend an annulment by this House, which we have done, whereby the requisite law, the Constitution, and the standing orders have not been followed. So that is the limit of our mandate, and actually we've done what has been provided for under the standing orders. So I also thank the committee for being the gatekeeper of the Kenyan citizens through this parliament, that all the regulations, all the statutory instruments that are brought before this house through parliament must also follow the law. And as a parting, as I finish, Honorable Speaker, it has also come to our knowledge as a Committee on Delegated Legislation that there are instances that the executive and some regulatory making bodies, they do what they normally call internally as directives, and those directives have a force of law. We want to caution them that anything that has been made and has a force of law with even consequences, that if you don't obey, you are supposed to face some consequences or some penalties. Those are statutory instruments and they should be brought to Parliament for consideration as provided by the Parent Act under which they are made. So, Honorable Speaker, without much ado, I beg to reply. Thank you, Honorable Speaker.
Thank you, and honorable members, for obvious reasons, we defer the putting of the question on that particular motion to the next time listed in the order paper. Next order.
Order number 14, motion, consideration of a petition regarding discrimination by the Teacher Service Commission on career progression guidelines for special needs education teachers in Kenya. Resumption of debate.
Honorable, debate on this motion started on yesterday, actually. And so if there's any member who has interest on this, if there is no interest on this, then I would order that the next time it comes up, the mover is called upon to reply. Next order.
Order number 15, motion, 7th report on the audited accounts of the National Government Constituencies Development Fund Board for the financial years 2016-17 to 2021-2022.
Are you ready to proceed with this? I see you got a number of them today.
Yeah, Mr. Speaker, I request that you allow me to move this motion next week because I was not fully prepared for this. And based on the members present, I have one member here who can second me, but we are not prepared to move the motion today. We thought it was too far in the order paper. Thank you, Mr. Speaker.
I would imagine that now you are informed about this, but then we stand down that order 15. Next order, is it the same for, go ahead.
Order number 16, motion, 8th report on the audited accounts of the National Government Affirmative Action Fund for the financial years 2016-2017 to 2021-2022.
Is it the same?
Same, Mr. Speaker.
For the convenience of the House, could you please call order 18 first?
Order number 18, motion, 9th report on the audited accounts of the National Government Constituencies Development Fund for constituencies in Nakuru County for the financial years 2013-14 to 2021 and 2022.
Honorable Mulungu, this is
it's the same.
It's the same matter. So
yes,
orders 18, 16 and 18 are stood over until next time they're in the order paper. Let's go back to order number 17. Let's go back to order number 17.
Order number 17, motion, report on the audited accounts for the Judiciary Mortgage Scheme Fund for the financial years 2011-2012 to 2021 to 2022.
Is the chairperson in the House? Who is the chairperson? Oh yeah, Honorable Fatuma had indicated that I think Ramadan, so she won't be around. We'll shoot over generally. Next order. Next order, please.
Order number 19, The Energy Amendment Bill, Senate Bill number 42 of 2023, second reading.
The Honorable Vicaria, you got 18 minutes. You able to move in those minutes? Okay, go ahead.
Not a very big issue. Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the House adopts the report of the Departmental Committee on Energy on the Energy Amendment Bill, Senate Bill number 42 of 2023. Honorable Speaker, the bill seeks to amend the Energy Act, Cap 314, by introducing a new section, 134A, to regulate energy purchase agreement and power purchase agreements entered into between power producer and electricity buying entities such as Kenya Power. The main objective of the bill, Honorable Speaker, is to enhance transparency, accountability, and prudent financial management in the procurement of electric power and to protect consumers from inflated electricity costs arising from non-transparent contracts. Honorable Speaker, the bill was published on the 30th October 2023 and read for the first time on the 24th April 2025. It was thereafter committed to the Departmental Committee pursuant to Standing Order number 127. In compliance with Article 118, Honorable Speaker, of the Constitution, the committee invited public participation and received submissions from the Ministry of Energy and Petroleum and stakeholders in the energy sector. In compliance with Article 1181B of the Constitution and Standing Order number 127.3, through the placement of adverts in the print media on 15th May 2025, the National Assembly invited the public and interested stakeholders to submit memoranda on the proposed amendment. Honorable Speaker, by close of business on the 28th Wednesday, May 2025 at 5 p.m., the committee did not receive any memorandum on the bill. Honorable Speaker, the committee invited Minister of Energy and Petroleum for a meeting on the 29th July 2025 to give their comments and proposals on the bill. In addition to the committee invited other stakeholders, including Or Power 4, Kipeto Energy PLC, Socian Energy Limited, and Lake Turkana Wind Power Limited for a meeting to give their comments and proposals on the bill. It is important to note that out of the stakeholders invited, apart from the ministry, only Socian Energy Limited appeared before the committee. Honorable Speaker, the committee carefully reviewed the bill clause by clause and considered all views received. Honorable Speaker, after considering the bill, the committee made the following key observation. 1, the bill refers only to energy purchase agreement. However, in practice, Honorable Speaker, Kenya Power enters into both energy purchase agreements and power purchase agreements. The two are different. Power is measured in megawatts, while energy is measured in megawatts per hour. The law must therefore clearly cover both to avoid ambiguity. Secondly, the proposed section 134A2 restates principles of public finance that are already provided for in the Constitution and other existing laws. The committee found this as unnecessary duplication. Thirdly, the proposed subsection 134A3 introduces procurement and feasibility study requirements that are already covered under the existing frameworks, such as the least cost power development plan and the public-private partnership framework. The committee noted that retaining these provisions may create legal conflicts and delay energy projects. Mr. Speaker, in view of this observation, the committee recommended that the House approves the bill with amendments. The key amendments proposed are: 1, to introduce a clear definition of energy purchase agreement to include both energy and power purchase agreements. 2, delete Section 2 to avoid duplication of constitutional principles. 3, to delete Section 3 to avoid legal conflict and unnecessary delays in procurement. And lastly, Honorable Speaker, to provide a transitional clause requiring existing agreement to comply with the law, with the new law within 6 months of commitment. Honorable Speaker, energy is a backbone of our economy. It affects industries, small businesses, households, and all the overall cost of living. While transparency and accountability in energy contracts are essential, we must also ensure that our laws are clear, consistent, and workable. The committee believes that the proposed amendment strengthens the bill to align it with existing law frameworks while protecting public interest. I therefore urge honorable members to support the report of the committee and approve the bill with the proposed amendment. Honorable Speaker, this is an amendment that came from the Senate and proposed by Honorable Sifuna, Senator Sifuna. He was trying to clean, but when we looked at the bill, as I've indicated, Honorable Speaker, it actually was a repetition of already the existing laws that are already there. And other than an exception of only one clause that we were bringing to the amendment on the definition to include both energy and power purchase agreement, Honorable Speaker, all the other proposals that he had proposed, we thought it was just a duplication and it might bring some conflict in future if allowed to go through. Honorable Speaker, I beg to move and ask my brother to second. Mheshimiwa Geshimo Wakili, asante.
Okay, we don't know I don't know he was your brother, but yeah, brother, Honorable Geshimo.
Honorable Speaker, in our custom, we call men of almost the same age brothers. So I believe that is where he is coming from. So, Honorable Speaker, let me second, I rise to second this bill, which has been moved by Honorable Gikaria. And Honorable Speaker, the committee has carefully considered the amendments that came from one of the members of the Senate, Honorable Sifuna, and thought is wise that there is no need to pass the amendments as they are in the bill, because that would amount to a lot of duplication on the existing laws already. And Honorable Speaker, the part that requires definition, which has been creating confusion and probably jeopardizing and compromising the consumers in terms of the power which is built. I think this is a debate that has also has found its way into this House through various members. I remember the Honorable Member for Laikipia, Honorable Jane Kagiri, brought up this matter, and which even went to the Energy Committee. It was deliberated there. Actually, the report was even brought to this committee. And Honorable Gikari has picked it from there. Actually, through that amendment, now that issue will be resolved. And to be fair to the existing agreements, the partners or the parties to the existing agreement, that exit clause is very, very important, so that, because law does not act retrospectively. So there could be some timelines they had already given themselves in those agreements. So that exit clause is also very, very important, and it ensures there is fairness even to the existing parties in those agreements. So, Honorable Speaker, since it's just one main clause with the sub-clauses that is being sought to be amended. I don't need to go beyond that point. I beg to second. Thank you, Honorable Speaker.
Members, I propose the question that the Energy Amendment Bill, Senate Bill number 42 of 2023, be now read a second time. The Honorable Oundo.
Thank you, Honorable Speaker. Let me also join my colleague in supporting the Energy Amendment Bill, Senate Bill number 45 of 2023, and as moved with the proposed amendments. And let me also commend the Secretary General of the biggest party, Edwin Sifuna, for having thought through it so that he comes through this bill that has found its way here. Honorable Speaker, and today I was in an engagement with the Cabinet Secretary in charge of industry, and one of the questions that we rose and we discussed with him was the cost of energy. And probably, Honorable Gikari, you need to educate the uneducated. I've never known the difference between energy and power. I thought the words can be used interchangeably. But you have said the difference is only in the units of measurement, where the difference is. As I go to take a cup of uji with our lab president, Uhuru Kenyatta, told us, I'll ask the engineers to explain for me the difference, because I know you're not an engineer in that line. You are a Catholic like me. So, Honorable Speaker, the issue of cost of power.
Catholic engineers and non-Catholic engineers.
Yes, you might not understand, but we met somewhere, and the environment was very tense. Then, those good days. Honorable Speaker, the issue of power in this country, the cost of power in this country, is a matter that we need to debate as a country and resolve. Actually, there are two limbs to the debate. One, is the amount of power in this country adequate to power this country and achieve Vision 2030 of being the most industrialized country? That's a debate I'm sure the chair will one day have to come to this house and convince people. Because there have been debates elsewhere that Kenya has got excess power. But the problem is scheduling, because everybody in this country operates within defined hours, known hours. People, households, everybody go to work in the morning, comes in the evening, they overload. All industries work during the day, they don't operate at night, so the load shedding becomes a big issue. Probably as a country, we must get that debate. Secondly, is the reliability, the evacuation of that power from the production point to another point. For example, Honorable Speaker, you are my neighbor, probably you don't suffer this problem because the energy slips in Siaya County. As in Busia, even when it drizzles, power disappears. And disappears for days and days. It can go even for 3, 4 days, continuously. You'll be told long stories, the line is old, the power station has been hit by lightning, those kind of things. So that's a second debate we must have. How can we stabilize power and ensure all parts of the country get power continuously to power the economy of this country? The third issue is the cost of power. When you do literature review, you Google elsewhere, you will be told Kenya, the tariffs in Kenya are some of the highest in Africa. Yet, every day, we have invested in power generation for generations past, for many years. Oil carrier, we have everything. What baffles everybody, how come the cost of power has never come down to the level that's affordable, that can support this economy? Is it like the banking sector? Is it like the domestic debt in this country that is controlled by cartels that cannot allow it to run by the market forces of demand and supply? Honorable Speaker, as I stand here, I have a very interesting case in my constituency. And I'll again go back to the chair to have a progress report. There are these people called Kudura, the solar powered people. A company, I think it's a Portuguese company or Spanish company, one of those. Honorable Speaker, can I shock you that the tariffs is about 80 bob per unit, compared to Kenya Power of about 2 shillings per unit. And they went and signed exclusive contract with the Ministry of Energy that where they have gone, where they have established, Kenya Power cannot take their line. You can imagine, Honorable Speaker, the exploitation. And that's why I wholly support the amendment moved by the Super Senator, Edwin Sifuna, to have these matters probably regulated in such a way that there's some kind of dashboard view before these contracts are signed. I can tell you, Honorable Speaker, whenever even that Kudura program, whenever there is little sun that cannot run the whole day, the entire system goes off. Because it's dealt with solar, we thought they would have big batteries to store the power, yet that doesn't happen. So, Honorable Speaker, you can never develop a country if you don't have power. When you look, even if you happen to overfly Kenya at night, Kenya is one of the most least lit countries, probably in Africa, this part of the world. And that's why, Honorable Speaker, our progress cannot move. Nobody is going to invest in this country in heavy manufacturing where the cost of electricity probably takes almost 40% of the operating costs. So that's why I live with you, the chair. We have had this discussion that there are very many initiatives ongoing. I remember the president somewhere made some remarks how they intend to bring a massive amount of power, and I think when the analyst sat down, they put him off, and the story just died that way. I hope, Honorable Speaker, Chair, the story is not dead, it's still alive, and I hope at one time or another, these grandiose ideas that we keep on banding around whenever we have a microphone in our hands come to fruition. They should not just become empty rhetoric to massage and excite the audience to be seen how well we can speak in English. Honorable Speaker, this country requires further and serious discussion so that we move forward to the next level, we avoid rhetoric and move forward to the next level. Honorable Speaker, as we move, Honorable Speaker and the Chairman, I want your support here. Some years back, in 2024, there was this last mile connectivity program, that the contract, the funding was renewed. Honorable Speaker, from 2024, the many schemes, even the President himself came to launch in Busia, none of them have ever taken off. The long stories continues. Honorable Speaker, Chair, we have now been branded liars. People who go and tell lies, yet we know very well nothing will happen. Can we get these programs running so that we get the people, wherever they are, they get power? Honorable Speaker, with those very few remarks, because time has run out, I beg to support the bill. I beg to support the committee's proposed recommendations for amendments, and we will do it, the committee of the whole House. Thank you, Honorable Speaker.
Thank you, all members. Debate on this bill will continue next time.
Time is up.
It is in the order paper. Order. What's out of order? Time has lapsed. Go ahead. What is out of order, Honorable Gikaria, before we rise?
Honorable Speaker, to be honest, it's only that I know Mheshimiwa Odo is always permanently in the House, but how I wish I would be able to give him an update.
Of course, you know you'll get a chance to reply.
I will do that once, because as he has said, to be
Order.
honest, okay.
You know very well that you had a chance to reply with the move of the bill. So just ensure the day you are replying, your friend, and you call him your brother, who is in the House, so that he can listen to your reply. All members, time now being 7:01 p.m., this House stands adjourned until Tuesday, the 24th of February 2026 at 2:30 p.m.